Hey, sorry, I was having technical difficulties for the last 30 something minutes. I apologize. Um let me see what's going on here, and I'll be right back. I'll be right back. Literally.
An opportunity to look at several things. I looked at the cases we talked about previously. There's two State v. White. There was State v. White that was at the 6th District appellate level, and then ultimately that case went up to the Ohio Supreme Court a couple of years later and was decided. There was also another case that I looked at that I mentioned. Bolton, State v. Bolton, 2018 Ohio 1551. Then I was able to go and look at our administrative code is 5120:1-8-03, and that talks about use of force in jail, and it establishes safety standards for jails.
All right, so I'm just doing this real quick while we're waiting for him to come back. I apologize. This was I totally was not that I didn't have my shit together. And yeah, so we're waiting for him to come back. Once he comes back, I'll resume from there. I do want to get this 30 minutes on the thing. So I'm going to shut up. Let's go. As soon as he comes back, we'll be back on with the other one.
And it talks about in regard to use of force, and then there's A, essential, B, essential. So I did look at that. I did look at what council provided. Did the state provide anything, or did they have anything? I know that defense provided something about 405. They dropped off an instruction that they were believing was essentially what the code, the administrative code, and what case law states as to the amount of force that they can use by a corrections officer in a jail type setting. Does the state have any information, or based on the case?
I wasn't able to wasn't able to communicate anything to the court.
Okay.
We do have, I had not seen what the defense proposed.
So
For the record, Judge, just to be clear, you're accurate. 405 is when we were able to finish up with proposed instruction, which was after the clerk's office closes at 4, so we did hand deliver a copy to the court, and at that time we also emailed a copy to Mr. Thompson. So we did make effort to get a copy to the state, and just for formality's sake, we will file the same with the clerk's office.
I think that in looking, I mean, I went through and I did.
All right, we're back
2.5
on this
pages
one.
of instruction similar to the instruction about
Sorry.
reasonable force and like officer and like situation, and then in that case, the trial judge went on to give an excessive force instruction. However, the court described that as extraneous, so irrelevant, unnecessary, I guess is what that was described as. And then in that case, they also talked about the issues with making that a affirmative defense. So based on that case, I'm reluctant to add the excessive force, because I think it's self-explanatory that if the force wasn't reasonable and necessary, then it was unreasonable and unnecessary, and then the situation is not permitted. And then I did look at the administrative code, and it does talk about the issues, but it was in a prison setting, and it wasn't in a jail setting. And again, it talked about excessive force or deadly force and non-deadly force, but it talked about it in a prison setting, and it described things in the prison that where you could use certain things, but it wasn't a jail setting. So I'm concerned that if I put that in there, that we're gonna get confusion between a jail setting and a prison setting. So I think the most important thing to do is stick with what we've got, because I think that is proper, and I think in this case, if you give them too much, you get into a situation where you instruct them too much. I do think to get where we need to be, it would say, in regard to the use of force authorized by a corrections officer as it relates to all the counts charged here, the use of force shall be limited to instances of justifiable self-defense, prevention of self-inflicted harm, and it describes those things. I think that will help us so that everybody understands that this instruction applies to all 3 counts. And that would be, I would plan on putting that right under the reckless homicide, but it would say as it relates to all the counts charged here. Any thoughts on that? No? Okay.
Judge, the part that, only part again, back to the affirmative defense, when you mentioned self-defense, that is an affirmative defense. So, and I don't think the claim here is self-defense.
No.
At least I haven't heard that. So, and I think everyone, well, I think it's fairly common knowledge that self-defense is an affirmative defense even to the jurors. So, when it says that, it worries me that they're gonna think that there's self-defense. And that's not, I don't think that's the case here, but I'm not sure, I guess.
I don't know that self-defense is anymore, is an affirmative defense anymore. I mean, I don't, under the current law, it was, I agree, it used to be. But now, if there's any evidence tending to show self-defense, the court's required to put the instruction in there, even if that evidence doesn't come from the defendant. Any evidence at all, it requires the court to put it in there. So I don't know necessarily that I would consider it affirmative defense, because the state has to now prove it wasn't self-defense beyond a reasonable doubt. If the issue is, if there's any evidence tending to show it, then the state has an option. So I'm not a big fan of that change in the law. I thought that it was, the way it was good, but I know the legislature doesn't listen to me.
I believe, my understanding was that it was not any less of a self-defense, it's simply a change in the law shifted the burden to the state.
Right.
But-
If it's raised.
But it didn't eliminate what would otherwise be considered an affirmative defense. It didn't eliminate that.
Yeah, it's confusing because what we think of affirmative defense is the defendant has the burden, and they've now burden shifted it and made the state prove it. So I don't know how they still call it an affirmative defense if it's burden on the state to prove it wasn't. It's almost like an element now of the charge.
Well, they didn't eliminate the term affirmative defense.
They did, they just changed the meaning. I
Well,
guess.
and my point in support of what Scott has said is, it's still confusing, it's not relevant to these matters, and I think that would be.
Well, I think what they're trying to say is an officer, whether it's an officer in a jail, a correctional officer in a jail, is allowed to use force to defend himself if he's being attacked. Now, I don't think anybody's gonna argue that that was the case.
Judge, you're right, Scott's right, we've never talked about self-defense, that could be in there, we're not gonna be discussing self-defense. There is some risk of some confusion, I suppose, by its inclusion. It's a correct statement of the law, we would defer to the court as to whether that's in there or not.
That comes out of, where that's coming from is the Ohio Administrative Code, which lists the ways a jail corrections officer is allowed to use force, and they list it in there, and it's one of the, and it makes sense, but I don't think it applies in this case.
If it's in there, I assume the prosecutor's going to indicate that, no one's talking about self-defense in this case.
Correct.
We're not gonna be talking about self-defense when I stand up.
No, there's other things in there that might be discussed, but not that one.
For sure, for sure.
So what I'll do is I'll make the changes, and
Let's
then
not forget.
we'll go forward and we're ready to hear, any changes to verdict forms, by the way, that anybody saw, did give you those. Or maybe you need to look at those a little bit
Yes.
more.
Yeah, they look okay, but fine, better not. Those are a little bit different, what do you instruct the jurors to do with put like a check mark? 'Cause they
I
go
tell them
through
to put an X or a check mark by their decision.
Okay.
I let them pick. Typically, they do an X, but I tell them an X or a check mark by the what they pick. And I come down and talk to them about verdict forms and how to fill them out, and it has to be unanimous, and they can't mark not guilty because they all can't agree. It's gotta be all one or all the other, and they're not allowed to mark anything on any of the forms until all 12 of them are in unanimous agreement that that's the right answer, and then they're allowed to mark it.
Yeah, Judge, I don't see anything, on the verdict forms that would be a problem.
Okay. Well, I'll make the changes to the jury instructions, and then, we'll have those ready, and we're ready for a defense case, as far as defense witnesses.
Judge, before we bring it in, we have fashioned a stipulation, might as well read
Okay,
that, make sure.
let's
it's
talk about that.
accurate. What we've drawn up, it's titled stipulation, so presume you can explain to the jury what the stipulation.
Yeah.
Parties stipulate the defendant's exhibit F, as in Frank, contains 2 video clips from the Richland County Jail video surveillance system. Both clips are from September 19, 2019 at approximately 3:15 a.m. during Alex Rios' booking process. Parties further stipulate that the person in the orange and white jumpsuit is Alexander Rios, and uniform corrections officer is Officer Michael Longshore.
So I can read that, you want me to read that to the jurors and
I think
and
so.
explain it as a stipulation?
And then we're gonna play the 2 clips without any commentary.
Okay.
There won't be anyone sitting there who would stand after this question about it, and then, we expect at that point we can rest.
Okay.
We have exhibits obviously to go over, we'll renew our Rule 29 motion based on the inclusion of the 2 video clips. And then we'll be.
Okay.
Put it back into the case. At that point, I don't know if you want to, put anything on the record with, our client's, decision not to testify.
Oh, sure, if you want.
You can do that at this time.
Yeah, let's do that.
If it's before that.
Yeah, for sure.
Your Honor, just a point of clarification as it relates to the instructions.
Yeah, sure.
This indicates that on or about the 19th day of September of 2019, and this is one of those unique situations where I believe that the course of conduct spilled into the 20th.
Okay.
So I'm wondering if we should probably say something into the 19th, into the 20th. I mean, I know it does say on or about, I'm just,
There is an instruction that I've used before that says, and this might fix it for you, the state does not have to prove an absolute date of an event, but just a time frame that's reasonably close. And and I've used that before, and I can probably fit that in here
That's
somewhere.
That's
And
fine.
then we can use on or about, and then we'll have that instruction that says, it's not that date, that time, it can be a time frame that's reasonable, you know. So.
That's agreeable to us.
No objection.
Okay.
Thank you.
Did you wanna put on about, you discussed with your client?
Yes, Judge, throughout pendency of this case, and specifically several times, including over the weekend, I've met personally with my client and discussed the prospect of his decision to testify or not. We continue to have those conversations following yesterday's recess, with anticipation being, the expectation being that we open up our case, have the opportunity to make that decision. My client has indicated that he is elected not to testify in this matter. Counsel with him, and that has been our advice as well.
Is that accurate, Mr. Cooper?
Yes.
All right, very good. All right, what we'll do is, bring the jurors in, I will read the stipulation, we'll play the exhibit, then defense will rest, we'll talk about exhibits, I'll make some changes, final changes to this jury instruction.
So, I'm gonna see what happens here. He's giving the final jury instructions. I guess we're in verdict watch at this point. Everything isn't lining up for me the way that yeah, that's what I get for having internet issues, I guess. Yeah. While the jury deliberates, I'll run the beginning of the proceedings to make up for that time that we lost, and provide some extra context if that's what we're doing right here, right now. Let's just wait this out a minute and see what happens. They said they're going to replay the thing, which, of course, you know me. I'm going to be doing this. A whole bunch of this. So, if you want to see the nasty tape, go ahead over to wherever they have it. Give me 1 second here. I gotta make a little couple adjustments. I don't know. Hopefully that's a little better. I don't know. We'll see as we go on. I don't think it is. But hey, who am I? What am I? Gotta get right up in this microphone in order for it to pick things up. So I'm gonna switch back over to the proceedings prior to this, so we can, so you know, you guys can get context to what's going on, and I can as well, because like I said, I was having internet issues. Well, I don't know. Here we go with the camera. See, I want to keep my eyes on this because I don't know what's going to unfold, what's not going to unfold. We'll see what happens. See what happens. Let's just take it 1 minute at a time here. Unreal. Again, my apologies. I should have been on this, been on top of it. It's totally my fault. Amateur mistakes. Amateur mistakes. But it's how you get started.
Richland County Common Police Court is back in session.
You may be seated. Welcome back, ladies and gentlemen. We're now in the defense's case, and to begin with, the defense and the prosecutor have reached what's called a stipulation. So a stipulation is essentially the parties agree to something. So we talked about what you can accept as true, and you have to look at the evidence, which is the testimony of witnesses and the exhibits. There's one more thing that you can accept as true. If the parties agree to a certain thing or agree that something's true, then you can accept it as true. And they've made an agreement here, and they're gonna actually play, it sounds like, a video or two. And the agreement essentially says, the stipulation says, the parties stipulate, in other words, they agree that this is true, that defendant's Exhibit F contains 2 video clips from the Richland County Jail video surveillance system. Both clips are from September 19th of 2019 at approximately 3:15 a.m. during Alex Rios' book-in process. The parties further stipulate that the person on the video in the orange and white jumpsuit is in fact Alexander Rios. And the uniformed corrections officer in the video is Officer Michael Longshore. So based on that stipulation, you can accept that what I just told you is in fact true. And we're gonna play that video at this time for you. Attorney Boone.
Thank you, Judge.
Here we go again. Or is this new video? Let's go. I've yet to see this angle.
Thank you, Judge.
Other than the stipulated exhibit, Attorney Mayor, does the defense have any other witnesses or any other evidence they want to offer?
Judge, with respect to our case, we do not intend to admit any more evidence or call any witnesses. We rest subject to the admission of our exhibits.
Okay. So ladies and gentlemen, what that means is the defense is going to rest, meaning they're not calling any other witnesses than what they offered here with this stipulated exhibit. What I need to do is exactly what I did last time when the prosecutor rested. I need to have a conversation with the attorneys and discuss their other exhibits, probably including the stipulated exhibit, and discuss admissibility and those kind of things. So we're gonna give you your break. We'll do that in here outside of your presence. When we come back, we're ready for jury instructions and closing arguments. So you've heard all the evidence you're gonna hear in the case at this point. After this, you'll have my jury instructions. You'll have part 1 and part 2 to listen to, then closing arguments from both sides, and I'll come back and finish with part 3. You don't have to try to memorize anything because you're gonna have copies of those jury instructions with you when you deliberate. You don't take notes during closing arguments. Closing arguments is exactly what the name implies. It's their effort to try to convince you to see the case the way they see it, but it's argument, it's not evidence. You heard the evidence from the witnesses. You saw the exhibits, which are also evidence, and the stipulation. But what the attorneys say is not evidence, so it's designed to assist you, it's designed to persuade you, but it's not evidence, so you don't need to take notes anymore. Upon finishing jury instructions, closing arguments, then we will come back and we'll figure out who the alternate is. And then I'll have some instructions for the alternate. After we figure out who the alternate is, the remaining 12, we'll turn the case over to you to decide. We'll all leave, we'll let you deliberate here in the courtroom. No one's gonna know what you're talking about except the 12 of you. If you do wanna review exhibits, then you're gonna have to bring the bailiff back in. For example, if you wanna play what was just played, if it's an exhibit in the case and you wanna play that, you need to bring the bailiff in. When the bailiff's in the courtroom, you're not deliberating. So you don't deliberate, don't discuss the case in front of her, wait till you see it, wait till she leaves, and then talk about what you saw. So there's certain evidence that, obviously, if it's digital evidence. The other thing is you're only gonna be allowed to see on an exhibit what you saw during the trial. So if only a portion was played during the trial of a video, you're only gonna be watching that exact portion. You can't watch before or after what wasn't played during the trial. So as long as it was played during the trial, then that's something you'd be permitted to examine and review again during deliberations. So we'll let you take your break. I know you just had one, but I'm gonna let you take one. We'll do our conversations in here about exhibits. When we're done, we'll bring you back in. Got the jury instructions ready to start reading them to you. We'll see you in a little bit. Thank you.
I'm gonna run that back one more time. Yeah, let's review that real fast while they're doing this. Let's review that real quick. Hold on. Let me see where I'm at. This. They're not saying how long this break is going to last. Wow. Hold on a minute, man.
I took out the part about Mr. Cooper testifying.
Switch over.
I made the changes, including
Of course, they switch it up. Why? Really?
I made sure that, and then on top of page 8, I put in the instruction the state requested it is not necessary that the state prove that the offenses were committed on the exact day as charged in the indictment. It is sufficient to prove the offenses took place on a date reasonably near the date. So, add that. Let's talk about exhibits. What exhibits are you offering, Attorney Mayor?
Just need a moment, Judge.
I think A was a map of the counties that use Montgomery County Coroner's Office for autopsy work.
It is, Judge. It was identified and authenticated by Dr. Lehman, and we moved to admit it.
Any objection to that one?
No good.
That's in. B1 was, B1, B2, and B3. B1 was a restraint chair policy, B2 was a taser policy, and B3 was use of force policy from Richland County Jail.
All three were reviewed in great detail and deliberation, time taken by Jamal Odell after taking, I don't know, about 10 minutes looking through all three exhibits in the B series. He did identify them as you indicated, and further indicated that they're a fair and accurate depiction of the restraint chair policy, the taser policy, and the use of force policy that was in effect back in 2019. So we believe that they have been properly identified and authenticated, testified to. We are asking that they be admitted.
Thoughts from the state?
Well, Your Honor, I would just say this, that I believe it's, he wasn't the author, obviously, of the, Mr. Odell was the only one who identified this, and it's clearly he's not the author. So it's hearsay, I guess, technically. I think he testified to it. I think that's sufficient. His testimony was sufficient. I think putting the actual policies in writing kind of, highlights it for the jury more so than necessary. For those reasons, sir.
Okay. I think that he did talk about them, and I think that he explained that they were in effect when he was there, so I think they can't come in over objections, so those are in. C was the 4 videos. I think that C is a duplicate of a state's exhibit.
C is a duplicate. We're had no objection to the state's version of the multiplex video. We are not looking at that evidence.
So C's out.
C's out.
D is the hospital medical records for Alex Rios from Med Central Ohio.
No objection.
No objection?
Move that.
Those are in. E is the pending cause of death, which I think you showed to Dr. Burwell. However, the state has already offered the actual document, not the pending document. Thoughts on that?
It just makes a complete record, Judge, of Dr. Burwell's work on the case and the certificate of death, both versions. And I think just allow the jury to see and understand how that process worked and confirm that with their understanding of the testimony. So we are asking to admit it.
Thoughts from the state? State may not object to it either.
And Dr. Burwell testified to it and said he filed it, so we don't have any objection.
F is a stipulated exhibit. That was something that was stipulated to by the parties. Any objection to, I think it's stipulated that it's coming in.
We'll just look to it.
All right, so that's.
Only as to it's already been established that they didn't show the entire video, and as the court has acknowledged, only as to that section that was illustrated to the jury.
We would need times, so anytime there's an exhibit that's used that we only showed a portion of it, we need to make sure that we give the bailiff the times, the start time and the stop time, so that we ensure that if the jurors do want to look at it, that they're only looking at exactly the time that was played.
And so with respect to the second clip that was played that is in the body scan room, we played the entirety. And with respect to the first clip, we can get the times. It should be noted that we are not concerned about any material that would otherwise be viewed in that entire clip. It's just simply an empty hallway. And so I don't know if we want to have Dawn have to go to the trouble of telling them times, or they could be directed at times, but it's not one of these situations where it's like, hey, make sure that they don't see the rest,
Right.
because that wasn't part of the case or something like that.
So you're indicating there's nothing prejudicial that the sites, and there's just.
It was
there's
something for
nothing-
the purpose of getting them to what they needed to see, at least in our view, which is the only activity that takes place on that first clip, that's several seconds.
Okay.
So we're comfortable, however, that gets taken care of.
The noted times would be appropriate.
That's fine.
Okay, that's fine. Very good. We'll just do the noted times for that. Anything else to discuss before we bring the jurors in and start?
We'll renew our motion for Rule 29 upon resting. Just ask that you consider the additional two exhibits that you saw, and the same arguments that were made. Also taking into consideration the law that will be applied now that the jury instructions have been finalized.
Yeah, same ruling as before. I don't think there's been anything different that's been offered that would change the court's overruling of Rule 29 motions. So what we'll do is bring the jurors back in, and I give them part one and part two of my instruction, then I let the parties argue, and then I'll come back and give them the last part, which is part three, right before we turn the case over to them to deliberate.
Before you bring the jury in,
Sure.
may we approach?
Yeah, come on up.
I could definitely say thank God he didn't throw the case out. But they're really, yeah. I mean, they're doing their job, right? They're definitely trying to get this ex-CO who is allowed to continue on with his career for a good while. There he is. Look at him. Ugh. I don't see any remorse in that man. I see fear. Fear. No remorse, just fear. Sad, man. It's sad. Sidebars. Hopefully soon I'll be able to get some moderators in here to give me some sound checks and things like that. That'd be nice. Wouldn't it? Come on, where's all my internet friends? Where are you? This morning. No, I'm just kidding. That was completely off topic, and I apologize. I really do. It's not me.
Now, it sounds like a good time. The jurors are not back from their break, but we do have people in the courtroom. Everybody's behaved like ladies and gentlemen. I really appreciate that. If there is a verdict in this case, and when there is a verdict in this case, obviously that's an emotional thing. Sometimes one side's upset, sometimes the other side's upset, sometimes both sides are upset, and everybody's behaved professionally. What I don't want is any emotional outbursts or anything like that. It doesn't mean that you can't feel a certain way, but in the courtroom we have to have a certain decorum, we have to have order and those kind of things. So when a verdict comes back, if you're unhappy with it, that's fine, but you got to keep that to yourself. You can't have anything expressed in front of the jury. And I'm not saying that anybody would do that, I just wanna make sure we put that out there, and I say it in every single trial, because I haven't had a trial in 10 years that a verdict, whether it's a civil case or a criminal case, where the verdict in some way or other upsets somebody. Sometimes, like I said, it upsets everybody in the courtroom. So everybody's behaved like ladies and gentlemen. I really appreciate it. I just want that to continue, even after the verdict is read in open court. So thank you for that.
You're welcome, sir. You're welcome. We try and have the utmost respect here. Keep it a little fun. Sometimes even a little greasy. That's what we're going to do. That's what we do. That's what we're going to do. We're going to continue to keep it real, as they say. But no, in all seriousness, I am going to be funny at times when it's not funny. I'm going to be, it's just, I have to. It's my way of dealing with things. And I apologize. I don't know. Some people want to constantly see me up there. I don't know. My ugly face. I don't know. Here we go.
So even though you're gonna have written copies of this to review, I still have to read it to you. So what I'm gonna do is I'm gonna read it to you. Like I said before you left, where I'm gonna read part 1 and part 2. Part 1 talks about what is evidence, what is proof beyond a reasonable doubt, how to evaluate the testimony of expert witnesses. That's all gonna be part 1 of my instructions. Part 2, I kind of call that the meat and potatoes of this. Part 2 includes the elements of the charges. Elements are what the prosecutor has to prove beyond a reasonable doubt. If it's not an element of a charge, then a prosecutor doesn't have to prove it at all. If it is an element of a charge, then the prosecutor has to prove that beyond a reasonable doubt before the defendant can be found guilty. So it's important to know what the elements of each charge are. So I'm going to give you those elements, and I'm going to give you some definitions. One thing you'll notice in every criminal case, there's 3 elements that are always the same in every charge. Now, the definitions or the charges may change, the elements may change underneath these 3, but there's always a date. The prosecutor always has to prove beyond a reasonable doubt on or about a certain date something happened. The prosecutor also has to prove beyond a reasonable doubt the venue, where it occurred. And in this case, they have to prove it happened in Richland County. And then the third element the prosecutor always has to prove beyond a reasonable doubt is the identity, who did it. So they have to prove that the person that they charge is the one that committed the offense. So those 3 are going to be the same in all 3 charges. But after that, they differ a little bit. We'll explain that. And like I said, those are the elements. That's what needs to be proven beyond a reasonable doubt. If it's an element, it has to be proven beyond a reasonable doubt. If it's not an element, it doesn't have to be proven by the state. That's part 2. Part 3, after the attorneys do their argument, and you're going to hear from the prosecutor, and then you're going to hear from defense counsel, and then you get a rebuttal argument from the prosecutor, because the prosecutor has the burden of proof. After we do that, I'll get to part 3 of my jury instructions, and that's how to deliberate in an orderly manner. You're going to have to pick a foreperson, those kind of things. How to let us know when you've reached your verdict, those kind of things. So those are the things we're going to talk about. So we know these jury instructions go with this case because it says jury instructions, State of Ohio versus Mark Cooper, case number 22 CR 813. The R just means it's Judge Robinson. If it was an N, it'd be Judge Nalmoff across the hall. So that's why it has an R on there. You have heard the evidence. Soon you will hear the arguments of the attorneys, but there's one more thing that you're going to need to decide this case, and that's the law that applies in this case, and I'm going to tell you that law now. As we've talked about throughout the entire trial, you as jurors and I as the judge have separate but related jobs. You decide all disputed facts, and I give you the instructions of law. It is your sworn duty to accept the law as I give it to you. You are not permitted to change the law nor apply your own idea of what you think the law should be. This criminal case began with the filing of papers charging Mark Cooper with crimes.
However, his response of not guilty puts into issue all the essential elements of the charges, of the crimes that are charged, and requires the prosecutor to prove every one of those elements. The defendant is presumed innocent until and unless his guilt is proven beyond a reasonable doubt. A person must be found not guilty of a charged crime unless the prosecutor produces evidence which convinces you beyond a reasonable doubt of every essential element of that crime. Note that the standard of proof is proof beyond a reasonable doubt, not proof beyond all possible doubt, and not proof beyond any shadow of a doubt. Reasonable doubt is present when you have carefully considered and compared all the evidence. You cannot say you are firmly convinced of the truth of the charge. Reasonable doubt is exactly what the name implies. It is a doubt that you have based on your reason and common sense. It is not mere possible doubt, because everything that relates to human affairs or depends on evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. What is evidence? We've talked about this several times. Evidence is the testimony received from the witnesses. Evidence is also the exhibits admitted during trial, and we had that one exhibit that was stipulated to. So stipulations are agreements of counsel. That's what evidence is. What evidence is not. Evidence does not include the indictment, which is the charging document. Evidence does not include the statements the lawyers made during trial unless it was one admitting certain facts by way of a stipulation. The opening statement to the attorneys, which you already heard, and the closing arguments, which you're about to hear, are designed to assist you, but they are not evidence. Questions or answers to which I sustain an objection or struck or instructed you to disregard are not evidence and must be treated as though you never heard them. You should not guess as to why I sustain an objection to any question or what the answer to that question might have been. You are not to consider as evidence any assertion of fact or suggestion an attorney included in a question which was not supported by evidence in the case. Evidence may be direct or circumstantial, or both, and both are valid kinds of evidence. Direct evidence is testimony by a witness who has seen or heard the facts to which he or she testifies. Direct evidence is also the exhibits admitted during trial. Circumstantial evidence is proof of certain facts and circumstances from which you may reasonably infer either related or connected facts, which naturally and logically follow according to the common experience of mankind. I like to use an easy example. Like I said, that direct and circumstances are both valid kinds of evidence, and we use it in our everyday lives. So direct evidence is something you saw, heard, smelled, tasted, or felt. So if you looked outside and you saw that it was snowing, you could come in and say on the witness stand, I saw it snowing. That's direct evidence of what you saw. And it could be something you heard, or something you felt, or something you tasted, or something like that. Direct evidence. Circumstantial evidence is a connected or related fact that you can infer from other facts that you find to have been proven. So, for example, if you looked outside and there was a blanket of snow on the ground, you could come in and testify there was snow on the ground, and that would be direct evidence that you saw it. Now, let's say you look outside, you see a blanket of snow on the ground, you come back an hour later, you look back out your front window, and now you see footprints in the snow. Well, you didn't see anybody walking there, but you saw footprints in the snow. The direct evidence would be, I saw footprints in the snow. The circumstantial evidence would be, well, somebody must have walked there, because that's how footprints get in the snow. So what I'm telling you is you're allowed to use those connected facts that you find from the direct evidence. You're allowed to use those related connected facts that naturally and logically follow according to the common experience of mankind. Either direct or circumstantial evidence of each and every essential element of the crime is sufficient to warrant a finding of guilty if it would satisfy you beyond a reasonable doubt. Now, you as the jurors are the sole judges of the facts and the weight of the evidence. In weighing the evidence, you must consider the credibility of the witnesses. Use the tests of truthfulness that you are accustomed to using in your daily lives. These tests include the appearance of each witness on the stand, the witness's manner of testifying, the reasonableness of that testimony, the opportunity the witness had to see, to hear, and to know the things concerning which he or she testified, the witness's accuracy of memory, frankness or lack of it, intelligence, interest, and bias, if any, together with all the facts and circumstances surrounding the testimony. Use these tests to give each witness's testimony such weight as you think is proper. Now, generally, a witness may not express an opinion. However, a person who follows a profession or special line of work may sometimes express an opinion because of that person's specialized education, knowledge, and experience. Now, in this case, we had 4 of those type of witnesses. We had Dr. Amanda Paul, Dr. Lee Lehman, Dr. Roger Mitchell, and Dr. Daniel Burwell. They were all permitted to express their opinions in their professional area of manner and cause of death. Such testimony is admitted for whatever assistance it may help you to arrive at a just verdict. You are instructed that the fact that a witness has specialized training does not mean that you are required to accept his or her opinion. Such opinions are only as reliable and are only entitled to so much trust as is merited by the witness's objectivity and by the reliability of the data and assumptions upon which those opinions were based. As with other witnesses' testimony, you alone will decide what weight to give this opinion testimony. Now, questions may have been asked in which an expert witness was asked to assume that certain facts were true and then give an opinion based on those assumptions. You must decide whether the assumed facts on which any expert witness based his or her opinions are true. If an assumed fact was not established, you will determine the effect of that failure on the value of the opinion of such expert. You are not required to believe the testimony of any witness simply because that witness was under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your duty as jurors to determine what testimony to believe and what testimony not to believe. The testimony of one witness, if believed by you, is sufficient to prove any disputed fact. In this case, Mark Cooper did not testify. Every person who is accused of a crime has an absolute constitutional right not to testify. So his decision not to testify must not be considered by you for any purpose, as it is not necessary that a defendant take the witness stand. That's part 1 of my instructions. We'll get to part 2. Part 2 is where we break down the actual charges and what the elements of those charges are. So in this case, Mark Cooper is charged with 2 types of involuntary manslaughter and 1 count of reckless homicide. He denies that he committed these crimes. I will now instruct you on the law that you need to evaluate these charges. First, in count 1, Mark Cooper is charged with the first type of involuntary manslaughter. Before you can find Mark Cooper guilty of involuntary manslaughter as charged in count 1, you must find beyond a reasonable doubt that on or about the 19th day of September 2019, and in Richland County, Ohio, Mr. Cooper did cause the death. And in the jury instructions, you'll see that we use the initials AR. That's just, we use that because protecting the victim's identity. But we all know that we're talking about Alex Rios when we talk about AR. So when you see AR in the jury instructions, you know we're talking about Alexander Rios. That's who it is. But did cause the death of AR as a proximate result of Mr. Cooper committing the offense of felonious assault. So at the top of page 4, that first paragraph, that contains all the elements of this charge, what the prosecutor has to prove. I told you the date. The prosecutor always has to prove on or about the 19th day of September 2019. They always got to prove venue in Richland County, Ohio. They always got to prove who, Mr. Cooper, and then did cause the death of AR as a proximate result of committing the offense of felonious assault. Those are all the elements the prosecutor must prove beyond a reasonable doubt. But if it's not in there, they don't have to prove it beyond a reasonable doubt. So what I need to do now is I need to define some of these terms for you. So I'm going to have to define cause for you, cause the death. I'm going to have to define for you what felonious assault is, because it's saying as a proximate result of committing the crime of felonious assault. So I'm going to have to define what that means for you. The state charges, first we'll talk about cause. The state charges that the act of the defendant caused the death of AR. Cause is an essential element of involuntary manslaughter. Cause is an act in which a natural and continuous sequence directly produces the death and without which it would not have occurred. The prosecutor claims that Mr. Cooper caused the death of Alexander Rios as a proximate result of committing the offense of felonious assault. The offense of felonious assault is to knowingly cause physical harm to another. Before you can find that the defendant committed the offense of felonious assault, you must find...
Serious, Judge.
Oh, I'm sorry. You're right.
I'm sorry to interrupt.
You're right. Please, I appreciate it. The offense of felonious assault is knowingly cause serious physical harm to another. And I'm going to define that for you. Before you can find that the defendant committed the offense of felonious assault, you must find beyond a reasonable doubt that Mr. Cooper knowingly caused serious physical harm to Alexander Rios, which then caused the death of Alexander Rios. So it talks about knowingly cause serious physical harm to another. That's part of the definition of felonious assault. So I have to define for you what it means to do something knowingly, and I have to define for you what it means, what serious physical harm is. So knowingly, a person acts knowingly, regardless of his purpose, when he is aware that his conduct will probably cause a certain result. A person knowingly causes serious physical harm to another when he is aware that his conduct will probably cause serious physical harm to another. A person has knowledge of circumstances when he is aware that such circumstances probably exist. Since you cannot look into the mind of another, knowledge is determined from all the facts and circumstances and evidence. You will determine from these facts and circumstances whether there existed at the time in the mind of the defendant an awareness of the probability that he would cause serious physical harm to Alex Rios. Serious physical harm to any person means any of the following: any physical harm that carries a substantial risk of death, or any physical harm that involves some permanent incapacity, whether partial or total, or that involves some temporary substantial incapacity, or any physical harm that involves some permanent disfigurement, or involves some temporary serious disfigurement, or any physical harm that involves acute pain of such duration as to result in substantial suffering, or that involves any degree of prolonged or intractable pain. If you find the prosecutor proved beyond a reasonable doubt all the essential elements of involuntary manslaughter as charged in count 1, as it just defined them for you, then your verdict must be guilty of that crime according to your findings. If you find, on the other hand, the prosecutor failed to prove beyond a reasonable doubt all the essential elements of involuntary manslaughter as charged in count 1, then your finding must be not guilty according to your findings. That's count 1. We'll move on to count 2. In count 2, Mark Cooper is charged with a second type of involuntary manslaughter. Before you can find Mark Cooper guilty of involuntary manslaughter as charged in count 2, you must find beyond a reasonable doubt that on or about the 19th day of September 2019, in Richland County, Ohio, Mr. Cooper did cause the death of Alexander Rios as a proximate result of Mr. Cooper committing the offense of assault. So remember, in count 1, it was felonious assault. In count 1 talked about serious physical harm. Count 2 talked about assault, and we're going to talk about physical harm as opposed to serious physical harm. I've already defined cause for you, so if you want to know what the definition of cause is, for count 2, just flip back to count 1 and it has that instruction of what cause means. The prosecutor claims that Mr. Cooper caused the death of Alexander Rios as a proximate result of committing the offense of assault. The offense of assault is to knowingly cause physical harm to another. Before you can find the defendant committed the offense of assault, you must find beyond a reasonable doubt that Mr. Cooper knowingly caused physical harm to Alexander Rios, which then caused the death of Alexander Rios. Knowing is the same definition again as it is in count 1. So count 1 and count 2, the word knowingly is the same definition. A person acts knowingly regardless of his purpose when he is aware that his conduct will probably cause a certain result. A person knowingly causes physical harm to another when he is aware that his conduct will probably cause physical harm to another. A person has knowledge of circumstances when he is aware that such circumstances probably exist. Since you cannot look into the mind of another, knowledge is determined from all facts and circumstances and evidence. You will determine from these facts and circumstances whether there existed at the time in the mind of the defendant an awareness of the probability that he would cause physical harm to Alexander Rios. Physical harm as opposed to serious physical harm, which I defined for you in count 1. Physical harm, which is part of count 2, means any injury, illness, or prolonged physiological impairment, regardless of how serious it is or how long it lasts. If you find the prosecutor proved beyond a reasonable doubt all the essential elements of involuntary manslaughter as charged in count 2, as it just defined them for you, then your verdict must be guilty of that crime according to your findings. If you find, on the other hand, the prosecutor failed to prove beyond a reasonable doubt any of the essential elements of involuntary manslaughter as charged in count 2, then your finding must be not guilty according to your findings. Count 3. In count 3, Mr. Cooper is charged with reckless homicide. Before you can find him guilty of reckless homicide, you must find beyond a reasonable doubt that on or about the 19th day of September 2019 in Richland County, Ohio, Mr. Cooper did recklessly cause the death of Alexander Rios. So the first thing we talked about knowingly. So under Ohio law, there's what we call mens rea, intent. So you have purposeful, to do something on purpose means I intended it to happen. Knowingly means you're aware that it would probably occur. Recklessly, we're gonna get into that, is the next one down. And then there's finally negligent, which is failure to reasonable care. So in this case, the two we're talking about in count 1 and 2, we're talking about knowingly. So they're not purposely, but knowingly. And then count 3, we're talking about recklessly. And then the last one is down here. And if I did something purposely, then I automatically did it knowingly, recklessly, and negligently. But the opposite is not true. I can do it negligently and not do it recklessly, purposely, or intentionally. I can do it recklessly and not do it knowingly or intentionally. So it works the way down, but it doesn't work the opposite way up. So what is recklessly? And I think it was discussed already by one of the attorneys earlier, I think mentioned, but the definition under Ohio law, a person acts recklessly when, with heedless indifference to the consequences, the person disregards a substantial and unjustifiable risk that the person's conduct is likely to cause a certain result or is likely to be of a certain nature. A person is reckless with respect to circumstances when, with heedless indifference to the consequences, the person disregards a substantial and unjustifiable risk that such circumstances are likely to exist in the death of any person. Substantial risk, as contrasted with remote or significant risk. Substantial risk means a strong possibility as contrasted with a remote or significant possibility that a certain result may occur or that certain circumstances may exist. Again, I've already defined cause for you, so I'm not going to define it again. It's the same definition for cause in count 1, in count 2, in count 3. It's all the same definition of cause. Count 1 and count 2, it's the same definition of knowing. In count 3, it's a different definition of reckless. If you find beyond a reasonable doubt that all the essential elements of reckless homicide, as I've just defined them for you, then your verdict must be guilty of that crime according to your findings. If, on the other hand, you find the prosecutor failed to prove beyond a reasonable doubt all the essential elements of reckless homicide, then your verdict must be not guilty of that crime according to your findings. In regard to the use of force authorized by a corrections officer as it relates to all the counts as charged in this case, the use of force shall be limited to instances of justifiable self-defense, prevention of self-inflicted harm, protection of others, prevention of riot, discharge of a firearm or other weapon, escape or other crime, and controlling or subduing an inmate who refuses to obey a staff command or order. Use of force shall be limited to the amount of force necessary to control a given situation. In no event may physical force be used as punishment. The kind and degree of force an officer may use in executing his duties is limited by what a reasonable officer in the same situation would believe is reasonably necessary in the same circumstances. To determine if the actions of the officer were reasonable, you must look at those facts which a reasonable officer in the same situation would have known at the moment the officer acted with force, and in light of the totality of the facts and circumstances confronting the officer at the time. Mr. Cooper is not guilty of a crime if he was authorized to use force and if the amount of force used was reasonable under the facts and circumstances in this case. It is not necessary that the state prove that the offenses were committed on the exact day as charged in the indictment. It is sufficient to prove that the offenses took place on a date reasonably near the date claimed. Each of the offenses in this case constitutes a separate and distinct matter. You must consider each charge and the evidence that applies to each charge separately, and you must state your findings as to each charge uninfluenced by your verdict as to the other charges. The defendant may be found guilty or not guilty of any one or more of the charges of the crimes that he's been charged with. What I'm going to do next, ladies and gentlemen, is come down there and go over the verdict forms with you. Verdict forms are how you're going to tell us what your verdict is in the case. So I want to go over this with you and just explain it to you a little bit. So how do we know it goes with this case? State of Ohio versus Mark Cooper. We're going to talk about count 1 right now.
Next page will be count 2, next page will be count 3. Talks about the case number 22 CR 813R. It says, note, all 12 jurors must agree on a finding before you can make your finding. So I always tell jurors, you're gonna put an X or a check mark by which box you decide. But you're not ready to mark anything on any one of these pages, so all 12 of you were in agreement. You can't mark not guilty because 6 of you think one way and 6 another. All 12 of you must say guilty, or all 12 of you must say not guilty before you're allowed to check or X which one you decide. Once you all 12 agree, then make your mark, and you all sign it in ink, and you date it, whatever day you make your decision. So that's how you do this. So count 1, this is involuntary manslaughter, and to help you out a little bit, the differences, it says by causing the death of AR by committing the offense of felonious assault. So that's what we're talking about in count 1. When you all 12 agree on the answer, sign it, date it, sign it in ink. You only sign it. By signing it, you're saying I agree with what I marked on there. So if you don't agree, don't sign it. You have to all 12 agree, mark it, and sign it. Flip on to count 2. Count 2 is the second type of involuntary manslaughter, and this is the one that talks about the offense of assault. So I put it in there so it's clear. The first one's talking about felonious assault, this one's talking about assault. Again, when all 12 of you agree on the answer, put your X or your check, sign it in ink and date it. On to count 3. Count 3, this is the recklessly causing the death of AR. You're going to, again, all 12 of you, once you all 12 agree, you're going to mark it, sign it in and date it. Any questions on how to fill out the verdict form? Nope? Okay. Before I go to part 3 of my jury instructions, we're going to hear from the attorneys with their closing arguments. First, we'll hear from the prosecution, then we'll hear from the defense, then we'll hear from the prosecution again. And then I'll come back and give you part 3 of my jury instructions. For the prosecution?
Thank you.
Yep.
Good morning, ladies and gentlemen. On behalf of Mr. Thompson and myself in the state of Ohio, thank you for your time and attention. You can tell you're paying attention to this case and taking it very seriously, as we all know it's a very serious case. So thank you for your time and attention. I have 2 opportunities to address you, as the judge has told you now several times. You'll hear from me now, which is called the opening portion of my closing argument. You'll hear from Mr. Mayor, I believe Mr. Mayor, and then you'll hear from me again in rebuttal. Because of that, the opening portion of my closing argument is generally very brief, but it is very important because I take this opportunity usually to read you the indictment and go over all the elements. Well, because in the jurisdiction that I usually practice in, the judge reads the instructions after I argue, but he's done that before, so I appreciate that. That makes a lot of sense to me, because I think before you hear what we think that the evidence showed in this case, that you need to know the law, right? It makes sense, because to hear it afterwards and to hear our arguments, and you're trying to go back and figure out, well, did he really say that or whatever. So I think it makes sense that you know all of the elements now, to each and every element of each and every offense. And the most important definition, in my view, and they're all important. You know, I got to prove each and every element beyond reasonable doubt. And we know that, we accept that, we believe we've done that in this case, okay? But knowingly, okay, it's not purpose, it's not intent, as the judge just very well explained it to you, okay? So if any of you start to say in deliberations, well, I didn't mean it, that's not what the elements are. He didn't do it on purpose. He didn't kill him on purpose. That's not what the elements are. And that's not what we charged. That's a different crime. That's murder. And he is not charged with murder, ladies and gentlemen. So that element, and I don't know that you're going to hear that or not. He didn't mean it. He didn't intend to. I don't think you're going to. We haven't heard much about that. But it's important because the discussions are easily had later on when you start talking about the facts of this case. Well, he didn't mean it. He didn't do it on purpose. Knowingly caused serious physical harm to Alexander Rios. Let's get that out of the way first. Serious physical harm. Mr. Rios died as a result of the actions of Mark Cooper. There can be no more serious physical harm than that. However, had he lived in a comatose state, which he did for 7 days, that's serious physical harm. Okay, and so that is felonious assault when you knowingly cause serious physical harm. Knowingly, a person acts knowingly, and the first phrase after that is the most important, regardless of his purpose. Regardless of his purpose. When he is aware that his conduct will probably cause a certain result. When a 250-pound man steps on the back of a prone individual on a concrete floor, you know that that probably will cause serious physical harm to that person. And when you think about it, that's the reason he did it. He was trying to keep him down and on the floor. And the reason you step on someone's back, in the back of their neck, in the place where he stood, is so that he can't breathe and so he can't get up. And that's why he did it. That wasn't an accident, right? That's why it has to be knowingly. But an accident would be, well, I thought I was stepping on something else. I didn't know I was stepping on a person. I knew I was stepping on something. That's accident. This wasn't accidental. When you watch that video, as you've seen many, many times, and I'm sure you're going to view it again, and you are going to view it again in my final close, you're going to see that not only did he knowingly place his foot in the middle of Alexander Rios' back, he intentionally did that. Absolutely intended to do it. After he got tased and ripped the wire out of his hand. That's what you're going to see, and that's what you have seen, okay? So that is a knowing act. It's not an accident, okay? And it's more than a reckless act. It's more than a reckless act, ladies and gentlemen. It's knowing. He knew what he was doing. And he did it so that Alexander Rios couldn't get up and couldn't breathe. It's not reasonable force. And then we go on to count two, and count two is to prevent the thought that, well, he knowingly did this act, but he didn't know he was causing serious physical harm, but you had to know it was physical harm, because what's the first thing you hear from Alexander Rios when Mark Cooper steps on his back? Ah! You heard that. You heard that, and that's when he says, ugh, that's when he steps on him. That's physical harm right there. Right there, he caused physical harm to him. That's assault. He's assaulting him. Because he's not authorized to do that, ladies and gentlemen. He's not. And we've heard all the testimony around that. So that's why count two is designed to prevent what some would say a miscarriage of justice, because you say, well, he didn't knowingly cause serious physical harm. He certainly caused physical harm, knowingly. Again, not purposely. And as a result of doing those acts in committing felonious assault and assault, Alexander Rios died. If those acts weren't committed by Mark Cooper, Alexander Rios is still with us today. Plain and simple. And so that caused his death. Those acts of felonious assault and assault caused his death, and that's what involuntary manslaughter is. Count three is called reckless homicide. And as the judge said, it's a lesser standard than knowingly. It's not purposely, it's not knowingly, it's reckless. It's reckless behavior. And the words there are extremely important also. With heedless indifference to known consequences, a person disregards a substantial or unjustifiable risk that the conduct will likely cause a certain result. And notice those words, likely cause a certain result. Not certainly will cause a certain result, likely. Well, when you prevent someone from breathing, that will likely cause a certain result, is death. And heedless indifference, okay? Indifference is you don't care, right? If I'm indifferent about something, I don't care. So heedless indifference, he has no care in the world for the safety of Mark Cooper when he's standing on his back. That is heedless indifference to the consequences that will likely result. Again, common sense tells all of us, when a 250-pound man stands on the back of a prone person on a cement floor with his hands behind him or outstretched and struggling, he can't breathe. And when you can't breathe, you can't get oxygen to your brain. And when you don't get oxygen to your brain, it results in a brain death, essentially, is what happened with Alex Rios. And when that happens, you can't breathe on your own, and you end up in the hospital on a ventilator for 7 days, as we know from the testimony. That's the cause, and that's the medicine. And how did we prove each and every one of those elements? Well, the video shows the knowing acts of Mark Cooper. The video shows that. And you heard some testimony about it from Mr. Odell, but Mr. Odell talked more about his own actions than he did about Mark Cooper's. But we've heard everyone talk about, because almost every witness, I think every witness, has seen the video. So the video is the evidence. The video is the crime, ladies and gentlemen. It's a very unusual opportunity that you as a jury, because usually we have to recreate the crime for you by witness testimony in every trial. We have people come in and testify, what happened next, what happened next, what happened next, and you're trying to get a picture in your mind. You saw it. You saw the crime, and you'll see it again. So you're in a very unique position. And so we have had medical experts testify that the cause of death, Mark Cooper's actions, caused Alexander Rios' death by, quite frankly, not letting him breathe, therefore not getting no oxygen to the brain. Mechanical asphyxia, positional asphyxia, we've heard those terms, and that's what Dr. Paul said, and that's what she would have ruled back then. Whatever you think about that, she righted a wrong, in her mind at least, and came in here and told you what she felt and what her opinion was, her expert opinion, and so did Dr. Mitchell. Now we understand that there's two other doctors that disagree and call it some now debunked junk science, junk medicine that doesn't exist. So that's what you have when you start hearing arguments about cause of death. That's what you have to determine. Those medical experts, did how they explained it to you make more sense? Positional asphyxia and mechanical asphyxia? Of course they did. Alexander Rios did not die of delirium, in a delirious state. You don't die from that. Sorry, you just don't. You die when you can't breathe. We all know that. And ladies and gentlemen, you saw the crime. It's really that simple. Mark Cooper prevented Alexander Rios from breathing, and he died as a result. Mark Cooper is guilty of involuntary manslaughter in both counts 1 and 2, and of reckless homicide. And when I'm done, I'm going to ask you to sign those guilty verdicts. Thank you.
Thank you, Assistant Prosecutor Salisbury. We'll now hear from Attorney Mayer with the defendant's closing argument.
Thank you, Judge. May I take just a moment to get set up? Morning, ladies and gentlemen. Just like the prosecutor, on behalf of the defense, we want to thank you for your attention in this case and commitment to listening to all the evidence. We have reached the point in the case that when we went through the voir dire process that we spoke so much about. And as we were narrowing the large group down to the small group that we have in front of us, the group that will ultimately make up 12 that will decide this case, we talked about the qualities of a good juror. You all talked about possessing those qualities in your mind, the ability to keep an open mind, the ability to follow the law, the ability to hold the state to their burden of proof beyond a reasonable doubt as to each and every essential element, the ability not to pre-decide the case until you've heard everything. We're counting on you to have done that. We are confident, now that we're at the portion where we can make these arguments to you, that you will return a verdict that is based on reason and common sense. A verdict of not guilty as to all 3 counts. And I'm going to talk in as much detail as I can during the time that I have with you this morning. We'll go through all the evidence that I think is relevant, break down video, some of what we saw in our case, and also, of course, the relevant evidence with respect to the video evidence that captures the entirety of the altercation between corrections officers and Alexander Rios. We talked in voir dire about the work of a police officer, a corrections officer, law enforcement in today's world. And we all were able to agree during that discussion that this is incredibly tough work. It is difficult work. It is dangerous work. Okay? These things are all relevant to this case because what you heard the judge talk about with respect to the concept of use of force is that Mark Cooper was authorized to use force as part of his job. And we'll talk about all the circumstances that allow for that and the training and the guidelines as to levels of force. And they all turn on the degree of resistance or threat that the individual inmate poses at the particular time. And so we'll talk about all of those things, but make no mistake, after listening to all this evidence, you have to be convinced the job in a jail is a difficult one for a corrections officer. And we can all accept that a jail is a place of rules. We heard about so many of them. And you're going to have defendants exhibit B, 1, 2, and 3. All of the relevant policies that were in effect at that time. The use of force policy, the use of the restraint chair policy, and the use of electronic stun devices, tasers, which we've heard a lot of testimony about. You're just going to have all of those. You heard the testimony, you're all paying attention, you're all taking notes. None of it's going to be surprising to you when you see it in black and white. You were focused and you were you've heard policies and training that you have in front of you will lead you to that conclusion that the use of force by the corrections staff on September 19th, 2019 was reasonable. All of the corrections officers, and most notably in this case, the only case as it relates to this incident, Mark Cooper. Now, without rules in the jail, I think we can all agree that there's chaos. And when there's chaos, there is danger. And so, what we know from the training, use of force continuum, when faced with these situations, officers like Mark Cooper, a thought process with respect to the use of force requires split-second decision-making under very trying and stressful conditions. You heard the testimony of Mr. Odell. He indicated in the 20-plus years that he was a corrections officer and ultimately a supervisor, this was the most challenging situation and most difficult restraint that he could recall being a part of. That is powerful testimony when you consider how long he had been doing that job and the supervisory capacity that he found himself in that day. We go on to note that these circumstances it's important to remember that almost all incidents faced by officers like this one are not scripted. They are not easy to understand, and they are not predictable as to the outcome. And so that's why what's happening in this courtroom is so unfair when we're breaking down second by second, frame by frame, with 20/20 hindsight, armchair quarterbacking by definition. We can sit here in the comfort of a chair, wearing a suit 4 years later, or sit up on that witness stand and say, pause, what's happening here? What's the judgment here? What's the force here? That's not how it happened in real time. That's common sense. That is not, well, there is no pause button. There is no opportunity to say, hold on, what about this? Each and every action that the officers took was in response to what they were faced with by the decisions made by Alexander Rios. And make no mistake, it is nothing short of a horrible, awful, tragic consequence of this event that he is no longer with us. And we can all feel for his family and the loss of life that he suffered. But we cannot look at the outcome alone and go back to fit the prosecutor's theory in order to punish the outcome. That's what we can't do. We all agree that sympathy cannot come into play when you are making a decision, in this case with respect to your verdict, or any decision that you're making in this case. Both sides took great care to discuss that, and the judge talked about that too. We want the case to be decided on the evidence, not the very difficult testimony from people like Alex's mother when she talks about the good in him and all of the good memories that she has. That's awful. She lost her son. But what relevance does that have to the use of force in this case? What relevance does that have as to the cause of death? If the prosecutor would like to tell you that in second close, I'd be happy to hear it. The answer is 0. Okay. The pictures of him, the family, it's meant to tug at your heartstrings a little bit. Okay? And again, to be clear, it is an awful thing. And it was an absolute accident and an unintended consequence of an event that Alex Rios precipitated. He had the opportunity 4, 5, 6 times to stand down, simply comply, and then for sure he would still be here. But the prosecutor is all the way on the other side of this. They say, ignore everything else you see on that tape and focus only on the actions of Mark Cooper during those 7 seconds. And when you do that, you will conclude that if he hadn't done that, Alex Rios would still be here today. They are all in on that when it comes to proximate cause, when it comes to cause. Without those actions, Alex Rios would still be alive. There is no one who can say that, having listened to this testimony. Specifically, Dr. Lehman came in and testified at length, and we're going to talk about that in great detail, but the bottom line is he indicated there is no way, in my mind, that those 7 seconds would have caused that death. Reasonable doubt on cause of death, right there. And we'll get to more on that. Now, this is not a case where the corrections officers had choice, okay? So many times when you speak and learn about, follow law enforcement deaths involving police encounters in on the streets. The question is, the person was just minding their own business, weren't doing anything wrong. Why did the officer have to approach in the first place? This person was not doing anything wrong. You hear that over and over and over again. In some of those cases, it appears that it may be true. And it was kind of indicated at the beginning of this case during opening statement by Mr. Thompson. Alex Rios was just pissed off. He was pissed. You're right. Alex Rios was in jail because he had a valid warrant for his arrest on a felony, and he was transported back to Richland County Jail. When he talks about I'm not supposed to be here over and over again, he was exactly where he was supposed to be. Okay? Not because the jail was looking to punish him or anything like that. He had a valid warrant for his arrest and he has to be brought in. That's law and order. Unlike situations on the street where police officers have to make a decision, should we engage this individual or not? Are they doing anything wrong or are they not? There is not that choice here. When you have what we're going to look at on this video, their job is to deal with that. What else are they supposed to do? So much so that they would not be doing their job effectively and would not be cut out for that if they're not engaging Mr. Rios in order to try to get him calmed down off that ledge, settle down and cuff up for his own safety. It is their job. Now,
Dry cell, no wall.
I want to talk about a topic that has come up throughout this entire trial. And before we break down reasonable use of force and cause of death, as we take a look at that video and discuss the expert testimony, I want to talk about the role of drugs in this case. Specifically, methamphetamine and the influence that it had on Alexander Rios at the critical time that we see on this video from beginning to end. Okay. The judge told you, it's right in these instructions, that there are two types of evidence for you to consider. There is direct evidence and there is circumstantial evidence. And every lawyer knows that if both, either direct or circumstantial, are believed by you, they're to be given equal weight. The judge gave the working definition that we're all familiar with, and I'm sure it makes sense to you in practice. Direct evidence are things that people see. Right? We have direct evidence of what happened in this case during the altercation based on this video. Circumstantial evidence are things that we don't necessarily see, but we're aware of. And if we believe those things to be true, they can all add up to an inference, just the same as if we saw it happen. Make sense? Okay? In the example of, if I see it snowing, I can say it snowed. If I go to bed at night and there's no snow on the ground, I wake up and there's snow in the morning, inference is reasonable, circumstantial evidence snowed overnight. It's the same thing. It snowed. It's the answer to that proposition. In this case, there is overwhelming circumstantial evidence to support one conclusion with respect to the influence that methamphetamine had on Alexander Rios in this particular situation, and it is critical. Okay? It was suggested during opening statement there would be no credible evidence to support any of that. Well, we agreed to disagree at that time, and I think that as it's played out, and I'm going to go over all of the evidence to support that and why it's relevant, right now I think that anyone reasonable would agree. What did we find out during the trial? Well, Alex's mother did testify, and aside from talking about his good qualities, family history, and all of that, she did give us some pretty important information as to the issue that drugs played in this case. Number one, she indicated that he'd been struggling with drug addiction for the better part of 12 years. She also indicated that there are, as is normally the case, just reasonable pockets of sobriety followed by relapses, troubles, and all that sort of thing. But most notably, she indicated that the most recent period of sobriety ended with a relapse 3 to 4 weeks prior to the events that occurred on September the 19th. And not just a relapse on any type of drug, methamphetamine, okay? So this is not a situation we were suggesting to you because he's got a presumptive positive for amphetamines that it must be meth without any history that this individual actually has used meth in the past. To the contrary, he's a meth abuser leading right up use straight from his own mother right to the time of his apprehension on September the 19th. He also had a previous heroin overdose, which indicates...
Objection.
I think it's argument. I think that came
case, so. That's the heroin, Judge, I don't think heroin overdose came out.
It did. It's in the
It's,
medical records.
but this is a good point to make. You remember the evidence. The attorneys are arguing to you, but in the end, it's what you recall that matters. And there's 12 of you to recall, 12 memories are better than one. So if any attorney misstates it, they're not doing it, in my opinion, on purpose. Nobody can remember everything exactly what was said. But if that was the testimony that you recall differently, it's different, but Attorney Merritt can argue.
Go ahead. Thank you, and I agree with that. I'm taking notes, it's been a lot of information. But I feel confident, and his mom testified that there was previous heroin abuse, and if you page through those medical records, you're gonna see that as well. Different drug, but it stands for the proposition that this was an individual who can take drugs to the amount that it causes his life to be endangered. Okay? It's a pattern of this type of abusive, self-destructive behavior. Now, we also found out that when the Wakeman Police Department came calling after the domestic disturbance up there, he's hiding in a crawl space, and the police had to look around for him for a period of time after he returned to the house. He knows the police are coming, apparently he's hiding. This creates the opportunity for him to make sure that he has drugs with him if he's gonna be in the jail. Okay? Now, in addition to that, his behavior on that video is 100% consistent with what anyone in their day-to-day lives would perceive as someone who is under the influence of some type of illegal drug. And that is consistent with the testimony of Dr. Lehman. Okay, and we'll get into all of those different behaviors as they go to evidence of methamphetamine intoxication and also triggering the delirious state that has been debated and discussed at length in this particular case. And then when he's to the hospital, we have the presumptive positive for amphetamines with a threshold of at least 1,000 nanograms per milliliter, which is a lot, okay? And that tells us the minimum. It gives us nothing as to how much. The amount could be astronomical. We just don't know. And I can tell you that the failure of law enforcement at the time, whether it was the sheriff's office or Agent Lehner to follow up, none of that is Mark Cooper's fault with respect to them not getting a confirmatory test. I can promise you that we would like nothing more than to have that confirmatory test so that we could confirm not just the methamphetamine and the levels, but anything else that would not have shown up in a presumptive positive urinary screen. Okay? But nobody says that's unreliable for what it tells us. That he had amphetamine in his system, and that is a component of methamphetamine. Okay? What else do we know? Well, on September 30th, 2019, when the autopsy occurs, he has a ruptured, torn plastic bag-like object in his stomach. This was incredibly relevant to the medical doctors at the scene, whether it was Amanda Paul at the time, okay, or Dr. Lehman and everyone else that they consulted with, because it stood for a very obvious conclusion, and coupled with all else they had was the presumptive positive and the behavior. Just on those alone, notwithstanding the other piece of evidence to support methamphetamine intoxication I've already been through with you, and that was central to their conclusion that methamphetamine intoxication was the triggering event that led to the delirium and ultimately his demise, byproduct of anoxic encephalopathy, okay? So they are giving an explanation in that report as to how he ended up with the lack of oxygen to the brain, okay? And there's a clear pathway to that that Dr. Lehman laid out. Reasonable experts can disagree, well-credentialed, well-qualified. It's for you to make determinations as to which perhaps to give more credit to, but no matter what, when they disagree, and they have to prove beyond a reasonable doubt, by definition, we're looking at that on cause. Now, in addition to that, follow-up investigation done by Agent Lehner on this issue. We heard some testimony from Dr. Paul. Well, I later found out that it probably wasn't methamphetamine at all because he was on ADHD medication. You all remember that? She wrote that, probably wrote some of that down. How would she have learned that? Well, she spoke to the prosecutors, we heard, 3 or 4 days before the trial. Agent Lehner here never interviewed her. But that just wasn't true. And she's relying on that, apparently, for this last-second change of opinion. Facts that are simply untrue. Because we know that Special Agent Lehner did full-scale ORS report, which is your prescription history, where we can find out what you have prescriptions for and when you were getting them filled. And he ran it all the way back to January 1st of 2018. And on that witness stand, he got up there and told us exactly what it showed. That Alex Rios did not have any prescription for any ADHD medication, Adderall or otherwise, or any amphetamine whatsoever that would otherwise have caused the presumptive positive for amphetamine. It all leads to one conclusion. But the connective tissue that brings it all together is the exhibit that we offer. Go ahead and roll that, Sean. Question that his mom wondered, well, how did he get the meth in jail? Was it given to him? Bring it in? How did that happen? Hours and hours of video. Agent Leonard indicates he never took a look at this, never pulled it. And so what we're looking at here, by stipulation, is video of the bookend process. We know what that is from testimony from Jamal Odell. It is agreed that this is Officer Longshore opening this door, and this is Alex Rios. Now, you're going to have that back there. You'll be able to get right up here and take a close look at whatever you want to, okay? But what I can tell you is when you do that, you can see that the purpose of what they're doing is to go in there and eventually putting through this body scanner, which is to prevent people from bringing illegal stuff into the jail, drugs or otherwise. And you've got Officer Longshore here leading the way and not paying any attention to what Alex Rios is doing in the background. And what's he doing? He's rooting around in his suit with specific attention to his rear end area. Everyone knows, and it's common sense, that when people are looking to hide drugs, a common place to do that is in body cavities, like your rectum, butt crack, anything like that, okay? And so when you watch this video, take a look at what he's up to. There's a term that we use in these courtrooms called furtive movements, and I'm sure some of you have heard of that. If you have, use your own working definition of that. But furtive movements are what you think they are. It's when you're making movements that suggest that you're doing something to otherwise hide or keep contraband from people that would otherwise be looking to find you with it, right? It's suspicious movements. So let's take a look now at this body scan process. We are not suggesting to you that you're going to watch this up close and that you're going to see Alex Rios swallow a baggie or anything like that. But as you've already taken a look at it once, pause. What you are going to notice is he's got something, a piece of paper or something rolled up in one hand, right, as he approaches and goes to step on the scanner. You're going to see it appears to have a track device and then an arch that he can be moved into. You're also going to notice, just by virtue of being able to take a look at it, that this is once again Officer Longshore again, and he's going to have a seat there behind this door with a window in it type object. And he's going to get busy doing some work on the keyboard. And ask yourself, does he appear to be paying attention to what Alex Rios is up to? He does not. But what is happening is Alex Rios is paying very close attention to the fact that Longshore is not watching. And once he becomes convinced of that, he gets right back to the business of rooting around in that suit back there in his rear end. Take a look. Checking him. Put the paper out. And here we go. For the life of me, why Longshore isn't paying attention to this or noticing and saying, what are you doing with your hand down your pants? Is beyond me. But the fact is, he's not. He's still looking down, pecking away at the keyboard, and Alex Rios rooting around to stop right now. Alex Rios's left hand has emerged from being in his suit for what amounts to, I don't know, 30, 45 seconds. Comes out now, he has looking directly down at what he has. He already had that paper. There's no need to look at that paper anymore. He already knows what that is. He's looking at what he pulled out of that suit, brings the paper up, and continue. Looks at Longshore, and now sets the paper over there. Hand back in the suit, nothing to see here maybe. Stands to reason that before this body scan ever got started, what he had on him ended up in that paper. You can bet dollars to donuts, it's what ended up in his belly. And every bit of your common sense and reason tells you that this is the process by which how he ended up with that methamphetamine in that jail. And it is the first triggering event that set forth the chain of events that ultimately led to what happened 12, 14 hours
That
later,
may be the case,
or longer, 20 hours later.
but him being on meth is not what's on trial here.
If he's not trying to bring stuff in, it never happens. If Longshore's doing his job, it's all over. Because every piece of evidence in this case suggests that Alex Rios is a guy that did not give police any trouble at all up in Wakeman. Now, was he hiding from them and making their job harder? Well, yeah. But they found it. We know that from Tony Mold. And when they did, they had to convince him to come out of that crawl space. Similar to what we're going to see on this video. We had one of those situations. The difference is up there, he was just compliant. As Tony said, came out cuffed up, without issue. Without issue. He's capable of otherwise, just the day before, capable of otherwise being compliant with reasonable law enforcement orders and being taken into custody. He's capable of not causing any problems during the booking procedure, going to the pod, not having any problems, by all accounts, until everything changes not long before these events down in the single cell. What is it that's triggering this? Come on. This is it. Use your common sense and reason. And when you do that, there's just one conclusion that's reasonable. All of those pieces of evidence are connected together to support the conclusion that he got himself high on meth by eating that baggie. Why? Who knows? Okay? When people do that, it could be for any number of reasons we've heard testimony about. You can use your common sense as to why that is. It doesn't matter. The bottom line is, whether it was to avoid getting caught with it for some reason, whether it was to do harm to himself, he was in a suicide suit based on stated that he was going to harm himself, or if it was just to get high. It doesn't matter. The point is that's what happened, and everything that occurred after occurs based on the state that he put himself in, okay? And for the state, during opening statement, and all these questioning about different things to try and suggest that that's not just what it is, okay, is the equivalent of taking Cindy Lou Who to bed, tucking her in with a glass of water and patting her on the head and going back to the business of trying to steal the Christmas tree, okay? You all know better, okay? Don't get hooked. Sometimes things are just exactly what they seem to be, okay? And so with that, now we're gonna talk about excited delirium, we're gonna talk about Dr. Mitchell's testimony, we're gonna talk about everything that happened with respect to the actions of the corrections officers, and we're gonna analyze that all through the eyes of what reasonableness, a reasonable officer, okay? Because what you're going to find when you study these jury instructions is exactly what the rules are with respect to the law when you consider the reasonableness, the actions, specifically as to Officer Cooper, but also any other actions that you want to look at. But make no mistake, this is not a situation, okay? You will never find the words complicity anywhere in this document, these jury instructions. Some of you may have some familiarity with that, some of you may not.
Objection. Arguing facts outside of evidence.
I don't think it is an evidence, so you have to make it to something that was an evidence.
Very good, okay? People can either commit crimes as a group, or they can act alone. We all understand that, right? If a group is gonna rob a bank, you might have a getaway driver, a lookout, and a stick-em-up guy, okay? When they all get caught, they're all responsible because they're all involved together. Regardless. This is not the theory of the state of Ohio in this case. Mr. Salisbury stood up very clearly, and all the testimony you've heard as they develop their case supports their single standalone theory that the actions of Cooper alone caused the death of Alex Rios, okay? Without those actions, Alex Rios would still be here. So remember that. Don't get caught up as we're talking about the actions of the other officers, because they're relevant to this. As we talk about what happened, as we talk about any struggle that he had to breathe associated with having the weight of not Cooper alone, but the weight of other officers as well, as they all reasonably tried to gain control of him, okay? And so, I think what we'd like to do is begin to play the video, Sean. And this is gonna be the multiplex, okay? I call it that. It's essentially the multiple camera angles. Here we go.
Rios, I need you to come down so we can. Okay. All right. All right. I'm not going to call anybody unless you come down from down here. Okay, this is the last time I'm going to ask you. I've asked you for like 5 minutes. I'm not going to do it anymore. Okay? We're going to put you in a restraint chair for your safety. Do not listening, be uninvited, causing a risk to harm yourself. We don't have time to continue that all night. Okay? All right, this is the last time I'm asking, and we're going to go on. We're going to go ahead and put you in a chair. All right. Come on down. No. Is that a yes or no? Go ahead and turn around, put your hands behind your back, and cuff up for me. If not, we're going to come get you. All right. No? Okay, we're coming to get you.
Okay. So this is the moments right before the buzzer's gonna be hit and the door will be open, and we all know what happens next, okay? I wanna talk about this first portion of this, okay? Now, there's been discussion about excited delirium, obviously, okay? And the first thing to become aware of as we argue about excited delirium, or the delirious state as it becomes in 2023, supported by all of these different factors. This is not the trial of excited delirium, okay? And the state can make every effort they want to make it that, but it is not, okay? Is excited delirium relevant to this? Of course it is, okay? And we don't run from any of that. And we're gonna talk about where excited delirium was in 2019 and where it is now. And the impact that had on layman's opinion here in court compared to layman's opinion back then. But this is the trial of Mark Cooper, okay? Mark Cooper doesn't have anything to do with it being determined that excited delirium is controversial, as Dr. Lehman described it, and that changes in thoughts and things of that nature have made it so, yes. Many different medical associations, notably the National Association of Medical Examiners, no longer endorses the use of excited delirium as a standalone cause of death. But in that same statement, as you know, as it has been read to you, okay, and you can make things say what you want them to say. You can call it debunked junk science if you're the state. Call it what the National Association of Medical Examiners says. We do not endorse it as a standalone cause of death. Instead, tell us in your cause of death what the triggering pattern is and the behaviors which would otherwise support the delirious state. And then continue to talk about the other circumstances and give your opinion for the cause of death in that manner, okay? There is nowhere where the National Association of Medical Examiners in that policy statement or anywhere else call it junk science or debunked or any of that. The term essentially has been canceled, okay? But the underlying basis as a cause of death remains. We just have to give more detail and explain and show our work for how we arrived there, okay? And so, with excited delirium, as it existed in 2019, and as it exists now, the delirious state, it has a pattern, okay? It is a group of findings. And Dr. Mitchell, for his part, agrees with every piece of that with respect to what it is and how people who use it as a cause of death must make those findings. And so we all agree on the criteria, okay? And so for refreshing purposes, it's been testified by anyone with background, but with best detail by Dr. Lehman, that the pattern is a syndrome which begins with an acute confusional state. Person goes from relatively normal to disoriented, okay? It's an acute onset. They are combative, often with law enforcement. They display agitation. They also exhibit increased strength, and that makes them difficult to restrain. But it has to be triggered by something. And as Dr. Lehman clearly pointed out and Dr. Mitchell agreed, I'd say Dr. Paul, but again, it's hard to recall much of anything that she had to say as it related to anything substantive, okay? And so much of what I have to say this morning is not gonna have anything to do with what she told you. Now, those are the criteria, but it has to be brought on by something, triggered. Dr. Lehman said that most commonly it's a stimulant drug that creates the delirious state, and you're under the influence of that in the form of drug intoxication. And in this case, he reasonably concluded, based on just a couple of those factors that we had, not the 12 to 13 that I've given you that have been demonstrated in this trial, that it was methamphetamine, which is a stimulant drug, okay? And so, you have to decide, does he appear to be in a confused state? Well, what do we know, okay? We know from the testimony from Jamal Odell that not only what we see on the video, but also what he was saying in the moments leading up to that. In addition to saying he's not supposed to be there, call the law. They are the law, okay? He is also indicating things like, hey, you've got this all wrong. They don't have any of it wrong, okay? He's also saying when people are coming in, getting booked in, that they have stolen his stuff, they have his stuff, okay? That's not just confused, that's delusional. He is not one with reality when he was just previously, okay? Triggering event. It all fits together like pieces of a puzzle. It's inconvenient for the state, and they went out and found someone who was happy to discredit it for a price, okay? But the facts are the facts. We know when he's up on that wall in a suicide gown that he poses a danger to himself, okay? And this is when we talk about reasonable use of force, which we'll talk about alongside cause of death analysis. When he's up on that wall, by definition, he is posing a risk to himself. What are the officers supposed to do? What is a reasonable response? They have a job to do. Goal number one in the jail setting, protect the inmate. Force can never be punishment. There is no punishment. There is no discipline that takes place in this case. They want to get him in that restraint chair if you read the policy because it's the last place that they can reasonably put him. It's the last spot in the jail that they can put him to protect him from himself. If they don't do that, they're on the hook for anything that happens in that cell to him. They have a job to do. And so, of course, Jamal Odell is not arguing with him. He's not yelling at him. He's not being hard on him. He's just talking to him, just like he did to you, calm, okay? Just telling him what it was, just like he did with you. Please come down. He gives him instructions on what to do. He demonstrated with me. Cuff up. For your own safety. Food flap. You saw it when you were down there. Does Rios do any of this? He does not. Is that the end of it? Well, it can't be, for all the reasons I just said. And so they prepare for what comes next. But make no mistake, he is demonstrating this agitation and this acute, confused, delusional state, okay? Now, at that point, when you look at the use of force continuum, he's at the bottom, okay, for sure, okay? But he doesn't stay there, and he doesn't stay there by his own acts, okay? He finds himself, I believe, at level 1 blue. He is at this point passively resistant. He's not responding to verbal cues. At this point, that's what they're trying to do. They're trying to talk him down, okay? What they can do when someone's not responding to those verbal cues is they can put hands on the person in order to try and gain compliance. And that's where we are right now. And that's what they are preparing to do. And that's what would have happened but for what Rios does next. Please. less than 1 second from the moment that door's buzzed that Alex Rios is out of that cell as if he has been shot out of a cannon. He goes through those 5 correction officers, none of them are Mark Cooper, by the way, 5 corrections officers as if they are not even there, like a knife through butter. And now, he has escaped his cell. He has broken detention, okay? This has relevance with respect to use of force, okay? And we will talk about that later. But there is no other way to define this. Whether you think that this escape attempt was going to result in him making his way onto Park Avenue and heading for the hills successfully is irrelevant. What is relevant is that's what he has done. This is an escape. And these officers have an absolute obligation and job and a responsibility to get him back into custody. And it is not over based on their training, not when he's wrestled to the ground. It is not over until he has been restrained, and as Jamal Odell indicated to you, that means cuffed and shackled and returned to his cell, or in this circumstance, the restraint chair, which was the plan. That's when this is over. That's when there is no more force to be used. Nothing about anything that's happening here is punishment or discipline. They are reacting to what this man has caused to occur. We have no idea what is up there in that control area with respect to access could be used as a weapon on himself or anyone else. We have no idea what his intentions are with respect to the officers, but they have a job to do, and that's to get him back under control. Now, it was mentioned that it only took 1 officer to take him down. Take a close look now that we have this extra video and see what happens next. Throws that officer off, and Officer Prendergast is able to get him to the ground. Stop. When he breaks that detention, he is actively resisting once he busts out of that door, all right? Actively resisting is defined for you. Active resistance, a subject actively resists when they take affirmative action to defeat an officer's ability to take custody or control. That is by definition what he's doing. That puts the officers in their reasonable response with force into a level 2 green scenario. And that's before he ever throws Officer 1 off of him and is taken to the ground by Officer Prendergast. With respect to level 2, as testified by Odell and what you'll have back there, policy and training for these officers indicates that when this is the case, actively resistant, stunning, striking muscle groups, balance displacement, take to the ground, takedown techniques, okay? Read them all. These techniques may include the use of restraints, forced movement, forcing an inmate's limbs behind his back, because that's the protocol for cuffing, okay? And that's what gets us to this prone position here once they're able to gain control of him, even enough to do that. Use of rough physical force, okay? That's what the training calls for. And the last line on level 2, the last line, which is so powerful, once inmates are perceived as actively resistant, officers should not relax care until the subject is fully secured and in an isolated cell, which is what I just told you. Fully secured means cuffed and shackled, okay? And so when we later get to the portion where they are still trying to get him to let go of the cuff, it's because they still can't get him cuffed. This is long after my client is on his back for those 7 seconds. Now, please continue. You can see him rising up to his knees. They are not pulling him up to his knees. All right. The fact that he's saying I'm not fighting is of absolutely zero consequence. We can all say whatever we want, but it's our actions that matter. Even Dr. Mitchell says, yeah, I don't know, there's really nothing I can make of that. He's saying that. But what he's doing is what it is. And he is doing everything he can to work against the efforts of these 5 officers. Odell tells you that he initially had that camera, and he did. It took him a matter of seconds to realize and testify that he was concerned that the other officers could not gain control of Rios. So much so that he handed the camera to the female officer and immediately joined the fray. All right? All of this is happening, all right? All before Mark Cooper enters the scene. Jogging, we can see, about 1:35 into this, before he's done anything. Now, what we do have is about to be prone restraint, okay? We had testimony that irrespective of drug use, this is an adrenaline-inducing event for Alex Rios. Dr. Mitchell confirmed that, Dr. Lehman. We've all been under the influence of adrenaline, pumped up. Clearly that's what's going on. Add the drug use to that. He is clearly combative. He is clearly fighting the restraint. All pieces to the criteria that help meet the definition of excited delirium. He is exerting himself. He is gassing himself. Imagine working, struggling to fight restraint and to fight being cuffed against 5 officers, up to 6, all working together to try to accomplish that one goal, okay? We've watched fighting sometimes, boxing, as Dr. Mitchell talked about, any type of wrestling, any type of MMA fighting. Just one guy wrestling with another guy for a period of 30 seconds, or boxing, wears them out, and these are elite athletes in fantastic condition, all right? This is a 28-year-old who's in pretty good shape, by all accounts, but he is gassing himself exponentially as this event continues, right? This is the effect of the delirious state is having on his body. As I understand this from the testimony, excited delirium works to make it so that your strength is increased, your attitude is combative, you are resistant to restraint. Everything you're doing is making it more difficult for the officers to get you under control and get you cuffed, including the increased strength, which all those officers talked about, according to Dr. Mitchell, when he read those reports of theirs and listened to their statements. They all independently talked about it, and you can just see it. But because of that, it is making it so the officers have to work harder and reasonably elevate the degree of force in order to gain the compliance. And that's what's happening outwardly with Rios. It's causing this reasonable use of force to elevate, to meet the level of resistance. But at the same time, on the inside of his body, it's taking its toll on him. And it becomes too much for him to bear, okay? Whether it's the effect of the drugs, the exertion, the struggle, the waiting that occurs on him, not just from Cooper, by the way, okay? We're gonna talk about that in detail. But all of it, the entirety of the event. And it's why Dr. Lehman says, I can't tell you ultimately what caused his death with respect to the actions. There's too much. You can't tell, okay? But what he does know is that it meets all the criteria for excited delirium. And so he lays out what triggered the delirious state, all of the evidence supporting the delirious state, and reaches the reasonable conclusion that it led to his lack of oxygen in his brain and the cardiac arrest. And oh, by the way, when you read the medical records, as Dr. Mitchell was directed to, the discharge diagnosis talks about cardiac arrest secondary to drug abuse. Everyone knows that taking drugs that are made in a bathtub without regulation is incredibly bad for you, and the risk is through the roof, okay? It is hard on your body. We're not calling this an overdose. We don't know how much it was that he had. We can't. But I will not minimize the potential effects that the drugs were having on him. They talk about you can't tell what that bag is. You can't tell what that bag is, all right? This is an unregulated business. When you buy drugs, methamphetamine, they don't give you some type of bag that says meth. You know, here's the suggested usage. These are back street deals, unregulated, and you get them in items that look just like that. Tie-offs, baggy, obvious. Continue.
I'm not even fighting!
Yes, you are. Awesome. All right, couple things here. Mark Cooper isn't involved in this event for 1 second before he has the misfortune of going in to attempt to help and do his job that he is tased. okay? Now there is a moment, 3 minutes and 9 seconds into this video that we will get to.
Can you skip back to that? 3 minutes and 5 seconds. Play it.
You can see my client over here with his hand braced against the wall, what appears to be most of his weight on his left foot. I would like to help. Pause. I would like to help. As he gestures with his hand. That is Mark Cooper saying, I would like to help. Not, I want to hurt Rios. Not, what can I do to do damage to this guy? I want to help. I want to help do my job and help my teammates accomplish what they are having such a hard time accomplishing, which is to gain compliance and get him restrained and handcuffed. Now, if we go back to where we were, this informs his behavior when he gets there. It tells us that's what he was looking to do. Just help. And they want to say, you can't get up, you can't put your weight on someone's back, okay? You can't put your foot on, you can't put your feet on, okay? Cooper just wants to help. He just wants to do his job. Where does he get tased? He gets tased in the right hand. How does that happen? Because when he's going in to offer help with the restraint, he goes in with his hands. Why? Because he has use of them. How long does that last? About 1 second. We know it hurts because he walks away from it immediately. He's in pain, and he's pulling that wire out so that the tasing stops. But that barb, that hook, is so deep in there that he can't get it out ultimately without medical attention. It has been described as painful, and that's just common sense. Who wants to sign up to have a taser dart shot into your web of your hand and your bone? Nobody. Not going to make it so your right hand ain't very useful to you. His intention was to help, and it was to help with his hands. But he wasn't able to do that because of the chaos of the situation. It's so chaotic that Longshore can't even get still enough to accurately shoot the taser in a direction that doesn't land on one of his colleagues. Keep going. There he goes. Pause. Upper left. Fighting for the taser. Okay? It has been suggested by the state, well, you can't tell. Maybe he just doesn't want to get tased, so he's trying to stop that. Okay? Listen, if you are a reasonable officer and you are tasing and use every pain compliance technique that they have, according to Odell, the purpose of these is not to punish. It is not to injure. They're not tasing him because they're mad at him. They're not attempting joint manipulations and wrist locks, any of these things for the purpose of punishment. It is to gain compliance, and that specific technique, these are all examples of pain compliance. What else do we know about people under the influence of excited delirium? We've had testimony to this. They are not compliant with pain techniques. They have high tolerance for pain. Odell said it was as if everything we were doing had no effect on him. Okay? The idea is, okay, he won't cuff up. We're going to have to go to the next step, which is the taser. Deploy it once, tase him. He responds. You can feel it. You can hear it. But it has no effect. This is the point again. Once he's wrestled to the ground, he can be done. Once he's got all these guys wrestling with him and now he's tased, just be done. You got me. I'm done. I'm done. I quit. Fine. Take me back to the cell. Sorry. It's over. Every opportunity that he has to comply with all of the reasonable force, he doubles down and says, I'm going to keep right on going. What are they supposed to do? They have a job to get him back into control. So, it is reasonable for Officer Cooper, who is watching this, okay, to conclude that now Rios has his hands on the taser. He's trying to get control of it. These things escape attempting to disarm an officer are in black and white in that use of force continuum that immediately elevates this to a level red use of force, which justifies deadly force, okay? We're not suggesting that that was ever the case, but it justifies it. Please continue.
Ow! 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 All right! Ow! Ow! Can someone crazy? Can you explain to me?
Pause. Even then, you saw Mark Cooper was looking for an area and was struggling to find anywhere that he could get involved that didn't already have an officer making effort, okay? Dr. Mitchell was on this case for the better part of 2, maybe 3 years based on his testimony. Familiarity with jails, he knows that they've got cameras in addition to just this Sony handheld, and either he got it and just never bothered to look at it, or didn't get it and didn't call to follow up and ask why he didn't have it. The bottom line is that it is beyond negligent to come in and offer an opinion as to the cumulative effect that these officers had with respect to this restraint on this man's death, which is what he's up there trying to do. And the first time that he would have been given an opportunity to look at this video was live in court. That's not how it works. I'm not gonna have 3 years to slow it down and do a play-by-play and then give him an opportunity to make an expert opinion from 20 feet away when he's looking at a little corner. We already know how that's gonna go. It's an advocate position with an agenda. It stands for the proposition that his opinion is incomplete and not based on all of the most important evidence. And what I can tell you is, you get this back there, or out here, wherever you're watching it, once Mr. Rios finds himself within the view of this camera, which is for most of the prone restraint, I believe, you will never see the green of his smock. Never see it. Why? Well, it's not because my client is obscuring it. It's because there is not one moment when this officer right here, who the state has never even bothered to identify for you during this trial, okay? Because this officer right here, this one here, and this one here, and at times this one, are all on that man's torso, meaning Alex Rios, crawling around and exerting their body weight on him, and that is continuous throughout this. Now, I'm not saying any of that's unreasonable, but if you want to talk about he couldn't breathe, something that, by the way, when he's communicating throughout the duration of this, he never says. We all know that people who find themselves in these life or death restraints, to a man, will say, I can't breathe. That is never a phrase or anything remotely resembling trouble breathing that this man ever says. Watch closely. You will never see a moment that the weight of these individuals that are not Cooper are not obscuring his back in that green smoke. And that's just nowhere in the Mitchell calculus. He just wants to point in court at Cooper, despite what he writes in his report about the actions of all the officers collectively. Please continue.
Now here's the dumbass. I didn't say you were her. Oh, fucking took out on himself.
Pause. Pressure, weight. The only time that anyone can come into this courtroom, whether it's Dr. Mitchell, Dr. Lehman, or anyone else for that matter, and tell you anything about how much weight my client is applying to Alex Rios is during those 7 seconds. That's it. Even Dr. Mitchell conceded. And this is just common sense, which I'm sure all of you at different points in time have done. You stand on a scale, that's what you weigh when both feet are on. Obviously. As soon as one foot comes off that scale, weight drops exponentially. And it goes up and down based on how force is being applied. We have no idea how much weight my client, Mark Cooper, is bringing to bear when he is in this position here, which is just simply the position he's in for almost the entire time that he's involved with this.
just
Let's
these
see if
7
he
seconds
pivots and shows him
to
putting it
exclusion.
up against the
Everything
wall.
else in this case that they
All
want
of
you to
us
go back
wait.
and convict him for.
Objection.
It's argument, so you can respond.
Now, we can continue. Pause. We can see right there in the bottom left, Mark Cooper is showing, it's my hands where it hurts. Throughout this, you can see him continually shaking it, continually looking at it. Hurts him. It has his attention. He's paying attention to that, as anyone would who's injured.
Yeah, it's called pain. You get involved in that situation, and shit's gonna happen. You signed up for the job.
He's on some type of. Keep playing.
Again, look at the continued wrestling. There's
Look at him leaning on the wall.
where he simply can give up his hands and be cuffed, and it's over. Please continue.
Leaning on the wall. Putting his pressure, his weight. Look at him. There he goes. All of his weight. Punk is. Punk.
Pause. A careful review of this video will confirm that this is Officer Prendergast down here in the corner, as who was identified struggling with the taser earlier in this video. You will see that this is the officer on the left side that is working to get that first cuff on the left side of Alex Rios. You can see that action going on right now.
Yeah, he thinks he's supposed to be out of there and.
We're done. Pause. 7 seconds. That's what they say this case comes down to.
Objection.
And it can be responded to in argument.
He's a punk. He's all on the wall, putting all of his weight on the back of him. He died of his
Not 9 minutes and
asphyxiation.
29 seconds.
Shit, what they say.
We heard Dr. Paul get up there and say, oh, this is just like George Floyd. No, it's not. It's offensive. George Floyd was handcuffed behind his back and not resisting an inch for 9 minutes and 29 seconds. Restrained.
It's a totally different case, bro.
That officer's knee was on his neck the entire time. Not a stitch of resistance. Compare that to what we see here. While that man said, I can't breathe, over and over. While individuals are watching 5 feet away say, he can't breathe. These two are watching 2 feet away, running tape. Not one person is talking about Officer Mahon in this case. And again, hindsight's 20/20, but everybody can play that game if we want to. She is in the best position to see what is happening in real time. She is not involved in any of the efforts to bring him under control. There is never a point in time where she suggests that anything should not be happening that is happening. There is never a point in time that she recognizes prior to the other officers that there has been a change in color with respect to his face, that he is, quote, turning blue. In fact, she's the last to mention that, I believe. Please continue. Like to help. Twice. Okay, this is 15 seconds or so. Listen, you can, just like the judge said, you rely on what you find to be the truth when you are running seconds and so forth to get to that point in this case. But this is 3 minutes and 24 seconds into this. I believe that my client is up on 2 feet for about 7 seconds from 250 to 257. All right. 15, 20, 25 seconds later, what do we hear? Let go of the cuff. Not once. 5 seconds later, let go of the cuff. Okay? What we know is down here, that's where Prender is trying to get a hold of that cuff and get him cuffed. If Dr. Mitchell has his way
It's all over as soon as Mark Cooper gets on his back. But the evidence doesn't support that. Alex Rios still has freedom of movement, and he is still, even 3 minutes and 25 seconds into this encounter, not arguably non-compliant, as Dr. Mitchell wrote in his report. Had to get called out for that, because it's just obvious. Not arguably, he is still non-compliant. And this cannot, based on the training and the job that they have to do, this restraint is not over until he is cuffed. And he's still holding on to that cuff. Please continue.
Get a pair of shackles.
Get a pair of shackles.
Where's the other hand?
Where's the other hand? Still working to get him cuffed.
Only have one hand.
Mark Cooper looking at his hand again. Pain. All these guys are exhausted.
You want a pair of shackles?
We're gonna sit here. Pause. We're gonna sit here 4 years later and break it down play by play and say what they should have did. I'd like to see any of these people in that same situation. Please continue.
Oh, I would too.
Alright, shackles.
Prender has slid down, and Mark Cooper has taken his place.
Shackle him down
And he
there.
has placed his knee down into the, I guess, lower.
Objection. Video speaks for itself.
Okay, I think he can point out what he sees, and then it's the, whatever the jurors see is.
You can see his knee there in the mid-back area, okay? And he supports it with his weight with his hand on his shoulder area, okay? Dr. Mitchell writes in his history regarding this event, as he opens his report. He's a 28-year-old man who was in a physical altercation with corrections. He was restrained by multiple officers in a prone position. He's writing the things that are important in his report. And he talks about multiple officers in a prone position. He testified, as did Lehman, that in a prone position puts someone in a vulnerable spot. Dr. Mitchell testified as to when it was that Mr. Rios first became in danger of death, okay? And what he testified to, ultimately, I believe on direct and cross, is that once he found himself in that prone position, before Mark Cooper ever was involved in this, he was in danger, okay? This is a critical moment, all right? Mr. Thompson said, well, if that was just brief, that position, then it wouldn't have been an issue. Mr. said, well, if it was brief, okay? But what's clear is this was not going to be brief. And if you remove Mark Cooper from it, it only stands to reason that this would have gone on longer. Period. Alex Rios was in danger at the moment those officers wrestled him and placed him in that prone position and began using all their body weight for leverage in order to gain control of him, which Odell said is fine, okay? He also indicated on direct exam that you can't put your foot, we're not trained to put our foot on the back or the neck area. But he later said, either on redirect or recross, somewhere in there, and I'm sure you have the notes, that's the training, but circumstances can cause us to do that. And we are trained to use leverage. And that's exactly what's happening here. Leverage is being used. But to be clear, in the Mitchell report, that's what he talks about as the beginning of the critical moments. He goes on to say he was handcuffed and tased during the restraint. Subsequent and due to the restraint, during the forced restraint, the body weight of several officers, he writes, was used, including the full weight of an officer who's still in the back. So he puts all of that together, not just the actions of Mark Cooper. He was handcuffed and tased. That's relevant. Subsequent and due to the restraint, meaning after the restraint, he became unresponsive. That's what he wrote back then as to when that happened. Subsequent. Not during. And certainly not after my client was on his back. He was transported to a local hospital, found presumptive positive for amphetamines, was pronounced dead 7 days later. You won't find much more about amphetamines in this report, because it's an inconvenient truth what that meant. And it doesn't suit the narrative or the agenda, right? Or the advocating position that he advances. Dr. Mitchell makes $500 an hour, worked 27 hours on this report, 7 hours in addition to that, was paid $35 after the report, and $3,500 to show up and testify. Doing the math, that's $20,500 to offer an opinion that he could have given within 5 minutes of watching this video, because it's just what he believes. And that's fine. He's an advocate, and he has an agenda. And it is driven from experiences very early on in his life as a medical student with respect to an officer-involved shooting of an unarmed person, where he was alarmed that that person did not, that officer spent no time in jail, okay, or prison. It was a game changer for him, as he said on his podcast. And it influences every aspect of testimony that he offers in cases just like this one all over this country. And it's opinion that he's paid handsomely for. He is polished, he's a professional witness, and he is a hired gun. And it makes him dangerous, because he believes that any time that a police officer or a corrections officer, anyone involved in law enforcement, is involved in an altercation with someone else, whether it's a restraint, intent matters not. Doesn't matter. Completely can be reasonable. If intent doesn't matter if the use of force is reasonable or not. He's going to call it a homicide if he can reasonably tie, in his words, the altercation to the death as the cause. Okay? That's who he is. Now, Dr. Lehman, on the other hand, is someone who has worked for the Montgomery County Coroner's Office for what seems to be his entire career. At the time was the #2, the chief deputy clerk. And he offers these opinions in the ordinary course of business. He's not paid to come in for a certain way of viewing it or not. He gets paid the same amount of money regardless of what his opinion is. He calls it like he sees it. And he could have tried to go like Dr. Paul, who's a little younger, maybe has different opinions politically of some of these things. Who knows? He could have said, well, hey, excited delirium's fallen out of favor. It was fine back then, but the easy thing for me to do would just be to go in there and say, fine, I disagree with excited delirium now. We'll go with this, and sure, we can call it a homicide. But that is not what he did. He laid out in very clear detail that his opinion has not changed one bit with respect to his cause of death in this case. Yes, he agrees lack of oxygen to the brain is ultimately what caused his death, but how he gets there has everything to do with the delirious state. Consideration that there is the altercation with the police officer, it's fine. With law enforcement corrections, that's fine.
I didn't
It
put
is,
that
it's
up
part
here.
of it.
I don't know what's
But
going on
he
with
cannot
this.
conclude from the evidence that he collected while supervising that autopsy that there was any evidence that it was the torso weighting or neck compression or torso compression, whatever they want to call it, that caused the death to any reasonable degree of scientific certainty. What he said is, I just can't tell for sure. What I do know is that I don't believe that 7 seconds on someone's back is going to cause their death, or the rear, or the base of their neck. It's not.
Nah.
And that's just common sense. He talked about studies he's done or looked at with respect to weighting. People having 225 pounds placed on their back for periods of time. No problems. Okay? And that's just common sense. If people died as a result of this type of thing, regardless of how he wants to answer the question, we would see these types of deaths on athletic fields, wrestling mats, all over this country, street fights, you name it. But we just don't. Because the human body's tougher than that. It just is. We can hold our breath for 15, 20 seconds. Nobody's going to fall over from lack of oxygen. It's common sense. Swimmers swim lengths of the pool back and forth, not come up for air. And they're just fine. because they're after Mark Cooper, they bring Dr. Mitchell in to say that's what it is, to the exclusion of everything else that happened.
Are there too big?
You know, so where's the later time?
Isn't that something too big? That's why this went out big?
Still, we have continued efforts to get the shackles on. We've got Officer Mahon in position there, looking dead at this, nothing to her. You won't find anything in the Mitchell report that talks about the positioning of my client's knee on his mid-back. You won't. Please continue.
Straight up into the chair. All right. Cooper, I'm behind you.
You can hear the team working together for the purpose of trying to get him into the chair, which would conclude with that. These are all just reasonable actions.
Good. You two ready? He's turning. Straight up.
Pause.
Sorry,
Now,
I'm not
with respect to
showing
intent,
that.
What happens next? As soon as there's the recognition that he is unresponsive, everyone immediately transitions to life-saving efforts.
Your Honor, I'm going to object the reference to intent. It's already been clearly established. That's not an element.
Okay. Well, yeah, I think it's argument, I don't quite understand, so I think
I
that.
think the reasonableness of the officer's actions is central to this. And also, this has been deemed an accident as manner of death, and so I think all of these actions are relevant to the argument of
It's well outside the instructions.
Well, again, there's great leeway in argument, and the state always gets an opportunity to follow up and make counter arguments, so I'll go ahead and take it. Is this a good time for a
think so.
lunch break? Let's do this. I don't know how much longer Attorney Mayor.
I would say about a half hour, Judge.
Okay, I don't limit attorneys, some judges will limit attorneys to a certain amount of time, I don't do that. I think it's important that you hear everything each side wants to say in a closing argument. You're not ready to decide the case, you're still not ready to form and express any opinions, and you're not ready to talk about it, any of that stuff, because we're not done yet. Take your hour lunch, come back, we'll finish up with the arguments and the instructions, then we're gonna turn it over to you to decide. See everybody in an hour.
There you guys have it for right now. For this moment in time. On a lunch break. I appreciate everybody who's here, who's continuing to watch along with me. It's obvious, right? That he had the drugs and he had the drugs, right? And he did go off because of that, correct? But they put him in the turtle suit prior to putting him into the cell, which should have been a dry cell. It should have been a dry cell. There shouldn't have been a place for him to climb up and make a danger to himself. They want to keep blaming all these other factors. It's not, you're blaming factors that are irrelevant. He stood on his neck. It's plain to see. I don't know. Yeah. Again, I'm not a judge. I'm not a lawyer. The facts are the facts. It's just, I don't know. I pray to God they see through this defense's bullshit. No, I'm not saying that they don't have valid points. There's valid points there, but in concerning the death of Alex Rios, it does not apply. It does not apply. This is obvious. Insubordination, a lack of awareness, and a complete disregard for human life. I understand he's dangerous, getting around, whatever. He could grab something. they already have other things in place for that. And if they had a thought that he was a danger to himself, like I said, he should be in that cell. We're going to go ahead and do this lunch break and then come back. Thank you very, very, very much for tuning in. I really do appreciate you all. We will be back. Oh, look at that. Anyways, that's not even I don't care about that. What I care about is seeing that this family gets what they're looking for and things are handled accordingly, not just based on some he goes everybody brings come on, man. Not everybody. I'm not going to sit here and say everybody brings shit into facilities, but at the same time, it's a common thing. They know things go on. This is common for them. It's common for them to deal with. And they should know that they need to put him in a dry cell. They go on about his heroin. That's not on trial here. What's on trial here is Mark Cooper. Mark Cooper, not the hell he got all charged up inside jail and popped out of the cell. It's none of that. None of that, because precautionary measures could have been taken to make sure that didn't happen. Now, I guess he snuck it back in himself in order to make it back into a cell with a because you notice they changed this. They took the off him and put him in the suicide suit. So into the turtle suit. Excuse me. It's a little hard to whatever. I know I'm yeah. So they put him in the suit. They know he's a threat to himself or others, and then put him into a cell that he can possibly get hurt. And then they want to call it after he does pop out of the cell because they pulled him out. I mean, they had him come out. They opened the door. He would have been better off in the cell, up on the thing. If he would have fell, he would have fell. It's my opinion, man. I don't know. It's just my opinion. And they can say all this bullshit about, oh, if you're in a situation. Yeah, damn right, if you're in the situation. I want to see somebody stand on one of their necks for 7 minutes and see what happens, especially after all that. Yeah, absolutely, he was gassed. He was worn out. No doubt he was worn out. That's not what took him away from this earth, man. That is not what took him away from this earth. I'm going to take a lunch. Thank you. I really do appreciate everybody. I do. I really, really do. I'm sorry for the technical difficulties along the way. It is what it is. I got to work this out. But we'll see what happens. I'm going to throw this other screen up real quick and put on some elevator music, I guess, for the time being until I can actually get something different. And then we'll get right back on this. But I can't wait to see what the jury has to say. I don't know if they're going to get the deliberations today. Who knows? I'm a little, I think it's clear cut. I would like to see them come back quickly because then, they've already had their mind made up. Or not. I don't know. I'm just here commentating on what's going on and doing whatever. So, God bless, all the best. Please stay tuned or come back, whatever. After this lunch break's over with, we're going to resume. I might come back a little sooner. Maybe. Probably. So, if you like to see my ugly face or hear my voice or whatever, come back. I don't know. I have more opinions that I'm going to give for sure. But here we go. Launch. And it's not now. Now it doesn't want. Okay. Nope, took it away. We took it away. Unbelievable. This thing does what it wants for some reason. If the music's too much, just let me know. I'll take it right down. It's just something for during this lunch break. Throw it in the chat. Let me know what you think, please. We shall return. Still here. We're still waiting. See what goes on. Wait, what am I saying? The Santucci's. Got some Santucci's coming. Switch this off real quick for a minute. I don't even know. Anyone's even gonna bother to. What the hell's going on here? I took it down. It's not coming down. Unbelievable. What's these? How's that? That works. I mean, I don't understand what's going on here. Yeah, cool. I want to remove it now. I mean, like, I don't understand. Okay, here we go. My fault. Entirely my fault. Yeah, looking at the wrong part. That's it. It'll get you smoked every time. Every time. Oh, Lord. Unbelievable. I'm so sorry. Yeah. Amateur hour. Can't say much more about that except for that, right? I really can't. Unreal. Get him. Gotta keep doing this because, parental things. It's not cool. I don't suggest anyone do what I'm doing. Yesterday was a good day to quit. Not today, not tomorrow, yesterday. Quit smoking. I apologize. But we are on launch. And I guarantee you, every one of them jurors' nerves are so shot that they're outside doing the same thing. So yeah, they keep trying to use different forms of how do I put it? Different tactics. They keep using different tactics to encourage the jury throughout the trial. Obviously, that's their job, right? They've been using different tactics, try everything. Hopefully, come back, get some some real what's going on. Just waiting. Just waiting. I think we're coming back. We got something. What we have just yet? I don't.
All right, channel 2, channel 2, channel 2.
We got the microphone.
Channel
check
2, channel 2, channel 2.
Check. Microphone.
And then channel 1, channel 1.
Check.
Channel 1, ABC, channel 1. Cool, appreciate it. Okay, I'm gonna shut everything down until the judge gets that.
Thank you, sir. Do you know approximately how much longer that will be? Apparently not. Ceiling vision. I don't know why they don't just leave it on that. Yep. So. My Santa, the dope cheese is here. I think. Yep. Shout out to the Dashers, man. Shout out to the Door Dashers. That don't mess with your food. But see, we tip. Take care of it. You gotta take care of them. It's actually a new thing now. If you do not tip them properly or put a tip at all in there, there's a chance that your food may not be delivered as quickly as you would like. So make sure you tip. Tip your servers. Tip your bartenders. Tip. Providing you with service. And, you don't look like a classless clown. But hopefully we'll be back shortly with this trial. Mark Cooper and his excited delirium about the situation that happened. I mean, I'd be fighting for my life too, for real. I'd be fighting for my life, but at the same time, I believe I would have stepped in. I would have definitely stepped in and said, like, look, I was definitely in the wrong. I didn't mean to do that. Like, if I truly didn't mean to do it. This is like, hey, I don't know, man. I just got a whole different view on things. What can I do? I'm just me. being me. I'll always be me, and that's that. Talk to you guys soon. just real quick. I want to show you where it's at. Santucci's, baby. Santucci's. I'm gonna have my lunch now. they got jokes.
Richland County
Here we go.
Police Court is back in session.
You may be seated. Mary, you may continue.
Thank you, Judge. Welcome back. When we left off, we had just finished reviewing front to back the entirety of that video with all of the moments that I wanted to specifically draw your attention to for purposes of argument and making points that I think are directly relevant to your determination in this case, both as to cause of death and reasonable use of force. As to cause of death, state would have you believe that what we witnessed in the different video compilations of this event constitute an excessive use of force. And we'll talk about that definition as it relates to its counterpoint, reasonable use of force, here in a moment. But it means what you think it means, okay? They describe this in opening statement as an abuse of force, as violent, all of these awful, terrible things. Dr. Mitchell talks about this as an altercation, a fight, ultimately leading to Mr. Rios' death. But then, we look at the autopsy findings. Remember, Dr. Mitchell was never in a position, obviously, through no fault of his own, to conduct the autopsy. The person in the best position, or people, to make an evaluation as to all of the relevant injury and noteworthy observations during the autopsy were Drs. Paul and Dr. Lehman. And those findings are contained within this coroner report that you will have. And when you consider that, always remember that the Montgomery County Coroner's Office handles autopsies for what is almost a third to half of the state of Ohio, so 30 plus, nearly 40 counties. This is not a fly-by-night operation. This is not an operation, as Dr. Mitchell wondered or asked the question in his book that I asked him about, are coroners and medical examiners complicit in an effort to shield law enforcement corrections, police officers from prosecution based on their determinations? Are they subject to pressure from outside agencies like police departments to make certain findings? And so all these questions were asked of Dr. Lehman, and it was just clear that there was never any time where anyone from Richland County, whether it was the Sheriff's Department, this Bob Ball who's come up a number of times in this case, not a soul ever approached Dr. Lehman or anyone else in this case from the Montgomery County Coroner's Office and made any effort to cause them to render an opinion as to cause of death in this case. And Dr. Lehman, who is a pretty calm guy, I think that's about the only time that he kind of sat up and was a bit offended at even the suggestion of such a thing. And he indicated to me that if anything like that had ever happened, Richland County wouldn't be represented in blue on that map anymore, because they have a job to do which is separate and apart from anyone else. And that's what they did in this case. Now, if what they're describing to you is this example, violent abuse of force, wouldn't you expect that when the body is examined both externally and internally, that we would see evidence of some form of injury anything on the body of Alexander Rios to support that. He quite literally barely has a scratch on him. I believe he has a total of 4 what can only be described as abrasions on different areas of his body that no one is associating as anything that was relevant as to the cause of death in this case. Notably, they want you to understand, in this case, with their theory, the actions of my client, Mark Cooper, with respect to any effect that him placing his body weight, either partial or in total, during those 7 seconds, as being the cause of death. And so, of course, in the head-to-toe examination, we want to see what evidence of injury is there anywhere on the base of the neck, which is an area of concern in this case, all right, on the neck, base of the neck for a short period of time, but all over the back itself. An external investigation revealed not a single sign of a bruise and no injury. The neck, unremarkable, no evidence of bruising. As to an internal examination of the neck, all of the structures are in place and unremarkable. We also want to take a look for anything like petechiae. There's been testimony about petechiae in this case, and Dr. Lehman indicated that in an asphyxiation case, it is not uncommon at all. That's why we look for those. The petechiae are the busted capillaries that appear in the whites of the eyes. May or may not have resolved itself during that time, but we can also look at the hospital records. You're going to see evidence of petechiae at the hospital. See a check. Evidence of petechiae in the mouth, busted capillaries, evidence of asphyxiation. In the internal neck structure, 0, no petechiae. It doesn't mean that there isn't some asphyxiation, but it's the type of thing that you would point at if it existed to confirm or support your opinion, and it does not exist. In fact, there are no injuries whatsoever on Mr. Rios' body that can be identified as having anything to do with this altercation with law enforcement, and specifically the actions of my client, Mark Cooper. Now, the other thing that happened, the conclusion of that autopsy, is this item was turned over to law enforcement, to Special Agent Rodriguez. This item that was described in the autopsy report as a torn, ruptured plastic bag-like object in the stomach. That's just how it's described by the people whose job it was to collect it and offer an opinion about it. Turned over to law enforcement because it's important. Rodriguez doesn't just take it home for the night and say, we'll deal with it tomorrow. He contacts the lead investigator on the case, Special Agent Lehner, who apparently thinks it's important enough to change whatever he was doing in order to meet Officer Rodriguez halfway between their destinations at the Delaware exit, Sunbury, for the purpose of, I want that evidence. He's going to take it up to Ridgefield to be preserved, but in the process of doing that, he became concerned that it was degrading, it was gassing up. Well, that's no good, because that means we might not be able to test it later. And so what's he do? He makes a pit stop at his old stomping grounds in Mansfield and uses our crime lab for the purpose of getting it all dried out and preserve it. And so it sits, and it sits, and it sits, and it sits. In opening statement, we heard from Prosecutor Thompson, and he told you, when he talked about no evidence of drug use in this case, meth or otherwise, that this bag was tested and there was no drugs in it. Well, that's just wrong, and we know that as a result of the evidence that's come out in this trial and the testimony of Agent Lenhart. Because what he told us is that he never, in the 4 years that this case was pending, filled out a piece of paper that said, hey, crime lab chemist, I'd like you to swab the inside of this item, all around it, and make a determination if there's the presence of any drugs or anything at all that could be tested. Never filled that out. And then if it was done, and if there was, tell us what it is and how much. Never happened. Well, why? How can that be? Why'd you take all those steps to preserve the item? Well, my experience as a law enforcement officer, I decided that the stomach acids probably ate it all away and there wasn't going to be anything in there to test anyways. Oh, okay. Not in your experience as a medical professional or a medical doctor, because we had 4 of those people testify in the state's case. And not a single one of them was asked that question by the prosecutor so as to actually confirm what is a hunch that he has. We're in the business of proving things beyond a reasonable doubt. We're looking for all the evidence, whether it's good or bad for our side. That's what they should be doing. And in 4 years with the opportunity, there isn't much that he did on the investigation, and that's fine. Sometimes there isn't a lot to do, who knows? But one thing that has to happen, when they go pulling this item out of this man's stomach, coupled with everything else that we know about the case, have it tested. Let's find out. This is the proof beyond a reasonable doubt business. This is the highest burden in the law, and it's theirs. They have the responsibility of eliminating doubt, right? Ignoring having this tested is a big deal. Also, over and over and over again, we've heard, well, there's no confirmatory testing on the presumptive positive, and that's fine, there isn't. But we have the presumptive positive. And what Special Agent Later said is, well, I just know that that evidence wasn't available. And then on cross, it's like, well, what you know is the retention policy. 10 days in, you found out that the retention policy is sometime less than a week or so, or 3, 4 days, whatever, for urine and or blood, because both of those were probably there. He finds that policy out, okay? And from that, he concludes, well, it's 10 days later, so it's not there. Why not ask the question? In the time that he's figuring that out, he could be on the phone, he could drive over to the hospital and say, hey, I'm investigating a serious matter. You had Mr. Rios here for 7 days. Of course they recall that. It's only 10 days later. Can you double check to see if any of the urine or the blood's still available? Didn't do it. This is bare minimum stuff. This is not CSI. This is not Law and Order. This is just what you would reasonably expect if you or anyone you cared about was on trial. It's not too much to ask. It's inconvenient. Doesn't fit the theory, so we're not going to investigate it. Instead, we're going to go looking to find out if baby's on ADHD medication, so we can rule it out. Where's the objectivity? And then we're going to go find an expert, like Dr. Mitchell, and we know what his agenda is. Okay, now, I want to talk about cause. All right, prosecutor's right. Judge gave it to you, heard it several hours ago. Cause is an act in which in a natural and continuous sequence directly produces the death, and without which it would not have occurred. The acts in this case that they claim caused the death of Alexander Rios are the actions of my client. That's their theory, okay? It sounded a lot to me throughout the trial that they're pinning all of that on the 7 seconds, okay? Sounds as though, based on the objection, they intended to appear and talk to you about the time when maybe some of his weight's on his shoulder and back area. It's fine. Neither one of those things, if you take them out of this case, could lead anyone to believe that the outcome would have been any different. Not reasonably. It's but for. Take this out, and is Mr. Rios still here today or not? We have experts on both sides of that. That's reasonable doubt on that issue. To be clear, there are 2 major topics to consider in this case that I've been talking about for the better part of the whole morning now into the afternoon. Cause of death, all right? It is our position that the state has failed to prove beyond a reasonable doubt that Alex Rios died based on our client's actions. That's cause of death, okay? Instead, we have competing theories and opinions on cause of death. Dr. Lehman takes into consideration everything and says, I just can't get to specifically which of those actions caused, okay? And he also doesn't rule out the obvious effects of the drugs, and he also doesn't rule out the delirium, the delirious state. This is just reasonable. Now, person acts knowingly, regardless of his purpose, when he is aware that his conduct will probably cause a certain result, okay? They have accused my client of committing felonious assault in count 1, okay? And that directly leads to the death. That's the theory on the F1, okay? So when you unpack that, a person acting knowingly, there is no one that believes that the act of putting weight on someone's back, shoulder, or base of neck area for the short duration that we see on this video is the type of act that makes you aware that your conduct will probably result in serious physical harm. If so, where is evidence of any of that with respect to the force or the pressure or anything that he brought to bear on Mr. Rios during that short period of time? Doesn't exist. He's not acting knowingly. Goes for harm as well. The other theory in this case is recklessness, okay? Now, that is defined for you as well. The judge also told you about the standard of care below that, which is negligence. Told you about what's above it with respect to knowingly impermanence. These are all accurate statements of the law. Suffice to say, as the judge indicated, we act negligently when we owe someone a duty of care. And our conduct falls below that. And harm or injury happens as a result. That's negligence, okay? That is a step below recklessness, okay? Because as the judge indicated, it works down the ladder. The greater can absorb the lesser with respect to these intent levels, but the lessers do not absorb the greater. Make sense? You have to work your way up, okay? So negligence is the floor, okay, if you're considering conduct, all right? That's not what we're talking about here, okay? If you think that anything that was done that day was negligent, has no bearing on recklessness, you very must be not guilty. With respect to recklessness, the definition is critical. A person acts recklessly when with heedless indifference to the consequences, the person disregards a substantial and unjustifiable risk that the person's conduct is likely to cause a certain result or likely to be of a certain nature. Heedless indifference to the consequences disregards a substantial and unjustifiable risk. But it goes on. A person is reckless with respect to circumstances when, with heedless indifference to the consequences, the person disregards a substantial and unjustifiable risk that such circumstances are likely to exist in the death of any person. I didn't agree with a whole lot that Mr. Salisbury had to say about this case during his time. And I'm sure that when he gets back up here, and I don't get a chance to comment afterwards because those are the rules, but I won't agree with a lot of it that comes after this. It's an adversarial process, right? You've all observed that firsthand over the course of this last week or so. But one thing I do agree with is that for you to find that my client, Mark Cooper, was reckless, you essentially have to draw the conclusion that he didn't care if Rios lived or died that day. Didn't care. It's like the dirt on the bottom of his shoe. Nothing can be further from the truth when you watch that video. There is not any observable behavior that suggests, not that comes out of his mouth, audibly, which you can hear, nor his actions that suggest that he is acting in a way that is meant to punish, which would be directly relevant to reasonableness of force. It's not to punish, or to intentionally injure. That is not what's going on here as far as this recklessness. To the contrary, he's just trying to help. That's it. He loses the use of his hand, and everything flows from there. He's looking for places where there's loss of control so that he can fill in as best he can to accomplish one goal, which is the collective goal, which is to bring him back into custody. Back to this, the use of force continuum. Once the wrestling match got going on the ground, and all of the officers are involved in trying to gain compliance without much success prior to Mark Cooper's arrival, we looked at the progression from level 1 to level 2. And we talked about level 2, right, as he broke the tension and as they're working to try and get him to the ground. Level 3, right, is wrestling with the officer, pushing the officer, The inmate is perceived by the officer to be assaultive and a threat to bodily harm. Jamal Odell confirmed all of these things, and he didn't even tell you that just by watching the video. You have to step into the position in this case of a reasonable officer faced with the same situation and circumstances as your task, okay? And so this video is incredibly helpful with respect to that. But so is Odell's testimony. When this happens, the officer's response is important. Striking, punching, kicking, baton, okay? Restraints, use of chemical weapons, electronic stun device, tasing. The appropriate level of response is defensive tactics. They may include impact weapons, hard fists, or any other reasonable means available and at hand to stop the aggression, defend against the attack, and bring the inmate into compliance. Any reasonable means, okay? It's exactly what Mark Cooper's doing when he's deciding to use his feet instead of his hands. This doesn't have the availability of the right. Where is it? Officer Odell said, well, it's certainly not in there. In this use of force continuum, where these officers at the time are made aware in their training that they are not allowed to use their feet as leverage or for weighting in order to help gain compliance. It's not in there. That was one of those Law and Order dun-dun moments, in my view, as far as importance, when Odell indicated that. And he didn't have to go back through there because he just knew it. You can spend the next day reading this line for line, it will never appear. And this is what guided the reasonableness of the officer's actions on that day. Now, what it does go on to say is that it is contemplated and understood, this is level 3 TAM, crucial. It is understood, and you heard it during the testimony, but I want to really highlight it. It is contemplated and understood that reasonable officers, while employing defensive tactics, may cause injury, serious injury, and in some isolated instances, death, without intending such consequences. And this is where the intent matters so much, because it's the reasonableness of the officer's actions. It's directly contemplated. Above all, the safety of the inmate is also talked about on page 1 of this document. But even when trying to accomplish that goal, it is contemplated that the worst unintended consequence can happen. It's a tragic reality in this case. Substantial risk is defined for you as it goes to recklessness, okay, as to the actions of what you are risking, whether substantially or otherwise. It has to be a substantial risk that you are indifferent to. A substantial risk, okay, means a strong possibility as contrasted with remote or even significant that a certain result may occur or that certain circumstances may exist, okay? Both Dr. Lehman and even Dr. Mitchell testified that cause of death, 6 million ways to die, is a really difficult task for the forensic pathologist to nail or pinpoint in every case. But there are a specific type of cases that Dr. Mitchell specifically wrote about in his book and confirmed here in court that are a cut above when it comes to identifying cause of death. And that are deaths that occur in this category, in custody deaths, deaths in a jail, okay? Because you have so many different competing factors and causes. I would submit that Dr. Mitchell has streamlined that and made that relatively easy. But I think that the larger proposition is true. These are incredibly difficult cases. And to label them homicide, make sure to understand this. When we talk, we're not talking about cause of death, okay? Manner of death. That's something that a coroner or medical examiner does, all right? But regardless of that label, we can argue about the role of intent and all of that with them, okay? Because what we're trying to avoid on both sides is weaponizing these findings so that they can be held up and say, well, look here, it says homicide, facilitating prosecutions, okay? And it goes for the other side, accident, okay, right? Those are the concerns, and so much so that even Dr. Mitchell will come in here and say, because he has to, because he's being honest about this, that determination, that labeling as to manner of death, the fact that he and I could still be talking, and there ain't never gonna be a point in time where he's gonna change his mind about that, and that's fine, okay? I'm sure that is the whole rabbit season, duck season bit, right? He ain't never gonna change his mind. But what he tells you about that agreement for us to disagree, and more importantly, that agreement that is across his profession, okay? It's a split with respect to these types of things, accidents or whatever, okay? That labeling, manner of death, homicide, has no bearing on the job that you all have to do. They know it, they're happy to concede it, it's just fact, okay? The legal construct of these three charges is your job, and Mitchell coming in and calling it a homicide is no evidence of that, none, okay? And so don't be hooked by that. Now, the last thing I want to talk to you about substantively is this discussion of use of force, reasonable use of force. And so, to be sure, you will be looking at that all over the words that are printed on page 7, okay? So much of what we do in this business, I think, makes for a difficult task for people that don't have the misfortune of having to sit around thinking about these things all the time, these legal concepts. But I don't think that coming in here and learning, before you heard this today, that a corrections officer or a police officer is authorized by job responsibility to use force, okay? That is in the job description, day one, when you sign on to be a corrections officer. It just is, which is what I was getting at when I'm saying this isn't a use of force reasonable yes or no. They don't have choices. They have to react. They have to make these decisions in split seconds. They don't get the benefit of hindsight 2020 or armchair quarterbacking. These events are unpredictable and they are stressful and the outcome is unknown. And armed with all of that, they have to act. There's no choice in that. And so when you read these instructions, that all just sort of stands to reason. And what they say is that in regard, and these apply to all three. I think you heard that, I think you know that, but man, I've done a lot of talking, I don't want you to forget what the judge told you. So these use of force standards, okay, these apply to all three of the charges, of the crimes charged against my client, okay? And so ultimately, you get to decide how you want to, how you conduct your deliberations is of no one's business but your own, okay? But I think that the task, we can give you some suggestions. You get down to the business back there, and you can either go about determining the reasonableness of the force, and if you determine that the force was reasonable, there's no need to talk about cause of death, so, okay? If you go the other direction, you can talk about cause of death first. If you come to the conclusion that we just can't tell, cause of death was not proven to us beyond a reasonable doubt, that's the end. Somehow you make it to part 2 of that, then you talk about reasonable force, okay? And so understand that these are separate analyses to engage in, and you go about them however you want. But never forget that on the defense side, we're talking about both of these concepts. There are layers to this. And we start with the cause of death, which we spoke about at length, and we focus on the reasonableness of the force as a completely separate conversation to have. Both of them, right? The prosecutor having this burden of proof beyond a reasonable doubt. Okay? Not our burden. Now, getting back to it. If you find, strike that, in regard to the use of force authorized by a corrections officer as it relates to all of the counts charged in this matter, the use of force shall be limited to instances of justifiable self-defense, it's not what we have here, Prevention of self-inflicted harm, that's what got this started, the concern over that. Protection of others, right? They're concerned about their own safety. Prevention of riot, that's always a concern, but this is more of a secure area. Discharge of a firearm or potential other weapon, okay? We've had the testimony and the concern over the attempt to disarm, hands on the taser. Escape, okay? These are all the circumstances, any one of them can cause the use of force to be reasonable. All of them are fine, but any one will do. And controlling or subduing an inmate who refuses to obey a staff command or order, which clearly we've got that from beginning to end, okay? And so that's the first piece to that, okay? Use of force shall be limited to the amount of force necessary to control a given situation. In no event may physical force be used as punishment. I don't think anybody's saying that. The kind and degree of force an officer may use in executing his duties is limited by what a reasonable officer, and this is where it gets really important, in the same situation, which is what I was just talking about with you, would believe is reasonably necessary in the same circumstances, okay, at that moment. Not sitting here 4 years later, pushing start, stop, pause, rewind, okay? We are specifically not using 20/20 hindsight here. We are recognizing and looking at this,
My
the inherent
co-host is a little
difficulties,
feisty right now.
the split-second decisions and the uncertainty of the outcome, not what we know is the outcome today. Such a critical distinction. It's a task that you all signed on for when you indicated that you could follow law and keep an open mind. So don't get that twisted. Now, with respect to that, it goes on. To determine if the actions of the officer were reasonable, you must look at those facts which a reasonable officer in the same situation would have known at the moment the officer acted with force and in light of the totality of the facts and circumstances confronting the officer at the time, which I guess I got a bit ahead of myself, but that is laying that out in very specific detail at that point, okay? Not going to go back and start talking about that video again and the actions of Mark Cooper, because this is the trial of Mark Cooper, not the other officers, okay? He's responsible for Mark Cooper's actions, okay? But if you look at what was available to him during that time and what he was observing and what he was dealing with, everything that he did in response to the escalation and the actions presented by Alexander Rios was just reasonable under the circumstances in order to bring about compliance consistent with the training. There is no choice. There's nothing else that can be done in that moment other than Alex Rios can call it off at any point in time. He was the person in control. They talk about recklessness as it relates to one of the standards to which his conduct is to be judged. Alex Rios was reckless.
Objection. I know this is argument, Your Honor, but now he's aligning a legal standard to the victim.
Well, you may, I guess you can use a different term if you want.
I can.
That'd be.
Showing heedless indifference to substantial or significant risk is what's going on when he gets himself under the influence of drugs and climbs up on that half wall and makes choice after choice after choice that reasonably caused the level of force to escalate. That's the recklessness. The reasonableness is the response that these officers had to meet that resistance and non-compliance with. Finally, and most importantly, Mark Cooper is not guilty of a crime if he was authorized to use force, which he was, and if the amount of force used under the facts and circumstances in this case was reasonable. There can be no conclusion on that. But remember, it's their burden. They have to prove beyond a reasonable doubt that it's not. Think about that, okay? Not my burden, not mine, theirs. You have to answer for yourself on the elements of everything in this case, whether it's knowingly, whether it's intent to cause serious physical harm, any harm, recklessness, significant risk, substantial risk, reasonableness of the force, cause of death. You have to apply the standards that you would use to make the decisions, you all remember this, in the most important of your affairs, okay, before acting. With respect to cause of death, how could anyone be convinced beyond a reasonable doubt when you have the competing expert opinions? How could anyone be convinced beyond a reasonable doubt as to the reasonableness of the force when you have the actions of Alex Rios and the officers doing their job and following their training to simply bring him back into compliance for his own safety ultimately and get him into that chair? You can't. It doesn't make the task any easier. It doesn't. It would be ignoring the obvious to say that this isn't an emotional trial. It would be ignoring the obvious to think about the task that you guys have in front of you. But it's one that you all indicated that you could undertake, follow your oath, and consider the evidence. Consider the evidence, not the tragic fallout. When you do that, we, on the defense side, Mark Cooper, we are confident in this process, and we are confident in the jury system. We are confident that you follow it. We are confident that you will apply that standard, proof beyond a reasonable doubt, to each and every aspect of this case. And when you do, we expect that you will return verdicts that are based on reason and common sense, the type of verdicts you can feel good about from the time you served on this jury, because you followed the law. And that is, Mark Cooper is not guilty on all 3 counts. Thank you. Appreciate your attention throughout.
Thank you, Attorney Mayor. Now we'll hear the prosecutor's rebuttal. Assistant Prosecutor Salisbury.
Well, ladies and gentlemen, we started this case last week. You know, obviously, word here was Monday, and then we started, we all went to the jail, saw where this happened, and then we had opening statements. And the first thing you hear from the defense after Mr. Thompson's opening statement is telling you that this case is about how Alexander Rios died. And the defense gets up in their opening, and you remember the first words out of his mouth? I couldn't disagree with that statement more. Remember when he said that? I couldn't disagree with that statement more. And then for the next week and a half, we've heard nothing but them arguing and refuting the cause of death that our expert witnesses told you how Alexander Rios died. And now they want you to latch on, when they said they hadn't, to latch on to Dr. Lehman and excited delirium. They have to. They have to have that, because if they don't, then you know how he died and how he actually died. Excited delirium. It's not even recognized anymore. But how many times did you hear that phrase from Mr. Mayor? He's still using it because he's got to get you to believe it. He's got to get you to believe excited delirium is a thing, and it's not. It's not. Not recognized anywhere by anyone with any type of credentials or credibility. It isn't. But he's got to get you to believe it. And he just spent about 2.5 hours trying to get you to believe it. Don't believe it. It's not to be believed by anyone anymore. Now, we talk about elements, and Mr. Mayor's absolutely right. We are in the beyond a reasonable doubt business, right? Remember when he just said that? And you can't speculate and blah, 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 right? Well, their defense exhibit that you saw, the scanner, right? Man, you talk about leaps and bounds and absolutely no evidence of what he says that shows. I mean, absolutely no evidence of that? Asking you to say that a guy scratching his behind is pulling drugs out of his behind and hiding them somehow, and that the guy sitting there watching the computer scan, which is what he was doing, was not paying attention? What do you think he was looking at? He's looking at the monitor of the scan. He's paying attention. That's how the drugs got into his system. Wait, did you see him put anything up into his mouth? You don't think that officer checked that piece of paper that he was holding in his hand, something he was authorized to have? Talk about leaps and bounds and no evidence and beyond. We're in the beyond a reasonable doubt business, ladies and gentlemen. But he stood here and had to make you believe that's what that happened, and that's methamphetamine, and that's what got into his stomach, and then he was intoxicated, and leap and leap and leap. I would love to hear the defense of Alex Rios if he were still alive. If we'd have charged him with possession of methamphetamine, and Mr. Mayor had to represent Alexander Rios. Can you imagine his closing argument? My God, ladies and gentlemen, there's no evidence. There's no evidence of methamphetamine. There's no evidence how it got there. There's no evidence that that's a bag. There's no, right? You would hear all that. And look at, ladies and gentlemen, I've never said it wasn't a baggie. I don't know. We don't know what it is. Everybody in this courtroom agreed to that. We don't know what it was in his stomach. Okay? That's a fact. That's the fact. And it wasn't tested for drugs. And to sit here and say that it was a baggie of methamphetamine is just not proof. It just isn't. But I'll tell you this. It doesn't matter. Because is what he's saying is if Alexander Rios was high, he deserved to die? Offensive? He talks about offensive? What in the world does methamphetamine have to do with him dying? Nobody has said this is an OD case. He said it wasn't. Alexander Rios didn't OD. Everybody knows what an OD looks like. You froth at the mouth, you go out, your eyes roll back in your head, right? We've all seen it. Hopefully no one's experienced it personally or with a loved one, but we all know what it is. That's not what happened. And that's not how he died. And he didn't deserve to die. People take methamphetamine all the time, all day long, and they don't die. It had nothing to do with his death. But he stood here and had to talk about it for an hour because you have to believe that because you got to trash the victim, right? Alexander Rios wasn't worth living. Isn't worth it. He's a drug addict. He relapsed. What does any of that have to do with it? That was the second line out of the defense opening. Alexander Rios was a drug addict. He'd been addicted to drugs and he just relapsed 2 or 3 weeks prior. Okay. Make sure they had to tell you it was a felony warrant. It was a felony warrant. And in quotes almost, right? Why do they have to say felony warrant? I wonder. Talk about irrelevant to this case. Why can't they just say warrant? Get a valid warrant for his arrest. Okay. No, but they said every time the word warrant came out of their mouth, it was felony warrant. Remember that? And that's just to dirty up the victim. That's all they've done this entire case. Besides argue with the experts that they can't argue with.
Them's the facts.
Mr. Mayor said it's unfair. He started out his closing argument by saying it's unfair. It's so unfair that we can go back and go frame by frame and watch what happened frame by frame. And it's so unfair that that's exactly what he did for you. It's exactly what he did for you. You mean unfair? That's evidence. That's evidence. And by the way, I think what he meant was it's unfair to judge after the fact when you're in that situation. Ladies and gentlemen, that's exactly the reason why you get trained. And exactly why, when I asked Mr. Odell, you don't want people in those situations that aren't trained. What is training for? That's exactly why you're trained. To make those split decisions. in crisis situations, in tough situations, in violent situations? Do we want untrained police officers? Do we want untrained corrections officers? Do we want untrained doctors operating? You have to know what to do when you're in a profession. And that's what this is. And that's why they're trained. So to say, well, it's unfair for us to sit back here and make split decisions when they're in a place, that's what they're trained to do. That's their job. And to just get up and say, oh, it's a tough job and he died, huh? Well, it's ridiculous. It's ridiculous. They're charged with keeping inmates safe. They're charged with that. We should expect that in this country. That when you go to jail, you're not going to die or get seriously injured. I don't care if you're high or you're not. Couldn't care less. Doesn't matter. You deserve to walk out of there alive, at the very least. And then when he's arguing and telling you that he disagrees with the cause of death, and we understand that we disagree on that. In opening, they called it I want to get it right. A use of force incident that went horribly wrong. Those were not my words. Those were the defense words. Horribly wrong. Yeah. Horribly wrong. That's what went horribly wrong. And Mr. Mayor also says, tragic consequences of this event. That sounds to me like a concession of cause of death. The consequences of this event, that's what we're saying. The consequences of that event, of him standing on his back, is death. That's cause. That's cause of death. So it seems to be an inconsistent argument to say those two things, it went wholly wrong, tragically wrong, whatever that quote I just said was, and they said in their opening, and the tragic consequences of this event. That's cause of death. I can't look at it any other way. I don't understand what that means if it doesn't mean that. He wants to, and he didn't mention anything about Dr. Paul and what she said. Just because she made a mistake or somebody told her something wrong about the ADD medicine, but what she said was, and why he doesn't want to talk about it is because she tells you what the cause of death was, and she tells you what the manner of death was. And she disagreed with the cause of death that she signed, and again, I said it in my other close, and I'll say it again, whatever you think of that, she shouldn't have signed it. Say it plain. She should not have signed that. She didn't agree with it. She signed it. But she didn't agree with it is the bottom line. And Mr. Mayor can say, last second, she switched at the last minute or whatever he said. No, she didn't. No, she didn't. She didn't come forward. Not the correct thing to do, probably. But she didn't change. She didn't think that was right. And she told you what she told you. She asked Dr. Lehman to change it. He said, nah, leave it as excited delivery. And you heard her, she did that. Just leave it as excited delivery. And then we met Dr. Lehman the next day, and you could kind of see him saying that, right? That's the kind of personality he had, right? Just leave it as excited delirium. We have half the state to service. We're under contract with half the state. We're pretty busy. Leave it as excited delirium. Being paid, by the way, by Richland County. Make no mistake about that. They're under contract with Richland County. Mr. Mayor also talks about him struggling and being gassed and being tired, meaning, I think, what he means by that is being tired, right, from the struggle. All of them were. And we can all appreciate that. I think that's absolutely true. But what happens when you get tired, ladies and gentlemen? What happens when you struggle? You need more air. You start breathing real hard, right? We've all been tired. We've all, ran and been tired and been out of breath. So much so you have to stop. You imagine if someone's standing on your back when you're trying to get more air because you're so tired and you're so gassed. So yeah, it can happen that quickly. But no, we have not said that the 7 seconds, by the way, when you watch it, you're going to see it's 8 seconds. And I don't want to nitpick for a second, but I think you'll see he stands with both feet on for 8 seconds. You do your own evaluation of the timing of that. But pressure on his back, on Mr. Rios' back by Mark Cooper lasted over 3 minutes. Almost 3 minutes. By the time he puts his foot on, not just the 8 seconds he stands with both feet, gets back off, gets off, kneels, and holds him down with his hand so hard so, and I pointed it out, and Dr. Burwell wouldn't agree, his forehead's turning red as how much pressure he's putting on him. Alexander Rios' face is blue at that point, and he's staring right at him. He's looking right at him. Reasonable? Reasonable? You think that's reasonable force? That cannot be anywhere construed as reasonable. The man was blue, not moving, and he still got his knee and his hand on his back, staring straight at his blue face. Still didn't get off him. And I'm going to play it for you in a minute here, but just for good measure, and pay attention to this, and the one I want you to pay attention to is in the bottom left-hand corner, is just for good measure when he's getting up off the kneel off him, he gives him a shot to the head. Now, did that cause him any injury? No. No, he slapped him in the head, okay? But it shows you how he felt. It shows you that he was mad. That's what that shows you. I want to help. I want to help the other officers subdue that man. He's not helping Alex Rios. I want to help. And then, a window into the defense, I guess, is,
he should have called that.
Mr. Rios never said he couldn't breathe. Oh, there we go. So it's his fault. It's his fault. Because surely, if he would have said, I can't breathe, then Mark Cooper would have hopped right off his back and helped him up and started giving him CPR, right? That's what would have happened. By the way, which he never did, if you don't notice that whole video. He's talking about the officers rendering first aid. Mark Cooper didn't.
No, he's worried about his hand. His hand.
But he didn't say it. Never heard him during that entire 5-minute struggle. Did you hear the words, I can't breathe? Is there some sort of rule that if you don't say you can't breathe, you're allowed to kill him? That's all you got to do. Man, if he'd have just said he couldn't breathe, how were we to know? I mean, forget the blue face and the non-movement and the stiffness and everything and the limp, but forget all that. I mean, how are we supposed to know? Because he never said it. He never said he couldn't breathe. And he's offended that we bring up George Floyd? Or Dr. Paul brought up George Floyd. We never did.
Yeah, the defense did that.
He wants to point to let go of the cuff twice after Alexander Rios is clearly unconscious. Well, ladies and gentlemen, I think we can all understand what happened there, that the cuff was trapped underneath the body with a bunch of people on top. They were trying to gain control over them, over him. And they couldn't pull his hand out from underneath his own body. And they're saying, let go of the cuff, let go of the cuff. It doesn't mean he's still breathing or still actively holding it, or maybe he was holding it before he went unconscious and they couldn't unclasp his hand, is a reasonable explanation to that. Them saying let go of the cuff, let go of the cuff, is no indication that he's breathing. None. But I'll tell you what it does. It gives you an insight into the whole attitude and temperature in the room, if you will. You have Mahan, who is the female, you hear screaming, "Tase him, tase him! Dry tase him!" Right? We hear that. We hear that. She's not happy. He calls somebody, Alexander Rios, in one of his last words, with "you're a dumbass." And Mahan, "No, you're the dumbass. Let go of the cuff. Let go of the cuff, Ralph." I'd love to hear the finish of that sentence that got cut off. Those officers were angry. They're angry. And I'm not saying they have a reason to be. You know, you're struggling, it's adrenaline, all that. But to act like this is just a calm thing and we're just, "Oh, please, cuff up, oh, please do this, do that." You saw rabbit punches to the head. You saw all of that. These officers were angry. And on top of all that that's going on, he gets tased. Now look, that's a bad thing, especially when you're not expecting it. And I guarantee you, Mark Cooper was not expecting to get tased. So I get it. But come on, ladies and gentlemen, you talk about reasonable inferences and using your common sense. You just went into what you were considering to join a fight and looking for some kind of space to get in there, and you get tased, as Mr. Mayor said, within a second, and you're walking away, and electric shock is going through your body right now as you're trying to pull the electric wire out of your hand. You don't think he was mad? Come on. Common sense and reason. I agree with Mr. Mayor. And I told you that in voir dire. Not asking you to put that aside. Every single person knows if that happened to them, you would instantly be angry. Doesn't feel good. It hurts. You've been electrocuted, for God's sake. So you're mad. And you're going to see the first thing he does when he gets back into that fray is step on the back. And it's like that. It's not like he went in there and went like this and he's leaning most of his weight. That's not how that was. You watch the video and you determine it. But I submit to you, what you're going to see is force. Bent knee, force on his back. Immediately after he pulls an electric prod out of his hand and stop getting electrocuted through his body, electrocution through his body. Mr. Mayor also made what seems to me to be a concession. He said to you in closing argument, if Cooper wasn't involved, this would have gone on longer. Yeah, because he would have still been living. I mean, again, I think that goes to cause of death. He's admitting that Cooper's actions caused him to stop breathing, therefore stop struggling. That's cause of death. As far as the autopsy goes, ladies and gentlemen, and Mr. Mayor's right, there's no injury, apparent injury. However, you heard Dr. Mitchell saying they didn't do what I would have done, which is dissect the muscles, subcutaneous examination of the muscles of the back and the upper neck, the upper back and the lower neck. Meaning, you're looking for deep tissue bruising. They didn't do it. They didn't do that. They didn't do those things that may or may not have been there. We don't know, but we never will know. And so, you know, as the state of Ohio, and the investigation has been criticized heavily by the defense. But you come and you have this, what we consider to be inept autopsy with only 17 or 18 photographs and this cause of death that doesn't exist in most reasonable medical opinions view. And so the easy thing to do, and I guess is what they're asking, is the easy thing for you to do is just go, nah, guess we don't know, guess we can't tell. Well, that's not justice. It's not justice. So we didn't stop. And so, yeah, we went out and we got an expert witness. And, you know, you hear from Mr. Mayor, hired gun, professional witness, whatever. I believe it was Mr. Mayor, when somebody in voir dire asked, you know, we were sort of talking about expert witnesses, if you remember all the way back to last Monday, and one of you asked a question, maybe not one of you, but somebody asked a question, well, are these expert witnesses paid? Do you remember Mr. Mayor's response? Because I do. Do you go to work? You get paid to go to work? Remember that? He's like, yeah, sure they get paid. Sure they get paid. That's what he said back last Monday. Now here Tuesday, hired gun, adding up, doing the math for you, telling you how much Dr. Mitchell made. You know, so what is it? I mean, yeah, we had to pay an expert witness. You think he's gonna come in here and do it for free? I mean, he got paid, yeah. Hired gun? No. That's where it's offensive, because a hired gun would be, hey, Dr. Mitchell, we want you to say this. Can you say this? Oh no, we'll go to somebody else. Hey, Dr. So-and-so. No, that's not what happened. We sent everything to Dr. Mitchell and we said, tell us what you think. Tell us what you think. And if he'd have come back and said, I think it's a cited delirium and I don't think that, you know, Cooper's actions had any play in the death, okay, then we would have accepted that and we wouldn't be here, quite frankly. We just wouldn't. But that's not what happened. We sent the materials to one witness, one person. We didn't shop. And he came back with an opinion. And that's what happened. And that's how it works. I mean, that's how it works. And again, of course he's going to get paid. Just like Mr. Mayor's getting paid, just like I'm getting paid to be here, okay? So let's get that out of the way. That doesn't have, if you think that Dr. Mitchell's opinion was bought, well, then find him not guilty. It wasn't bought. He's an advocate, and he's got an agenda. But he's an advocate like I'm an advocate for justice. There's nothing wrong with that. Why is that a dirty term? Advocate. He's an advocate for his client. That is not a dirty word. And it shouldn't be. And it shouldn't be used that way to insinuate that it is. And he's got an agenda. He's got an agenda to see justice done. There's nothing wrong with that. There's nothing wrong with that.
I don't like too many prosecutors. I'll tell you what, I like this dude. I really do.
So,
Clay
here's the
Sack,
thing
he's
when Mr. Mayor tries to put it too simply, or very simply, you got competing interests as the cause of death, and that's reasonable doubt. That is not true. That is not true. It is if you want to throw up your hands. But it's your job, and you took an oath to decide what it is, what the cause of death is. And then, I agree with Mr. Mayor, if you decide that the cause of death was Mark Cooper's actions, then you gotta go on to see if his force was reasonable. Okay? We'll get to that in a second. But think of it this way. Okay, we have Dr. Paul saying it's mechanical and positional asphyxia, and she wished she would have said it back then. Okay? And we have Dr. Mitchell saying mechanical asphyxia, positional asphyxia, causes brain anoxia. We all, encephalitis, we all know that. Died from lack of oxygen to the brain. But then you have Dr. Lehman coming in here, who, by the way, did not, and keep this in mind, did not perform the autopsy, okay? Supervised it, but did not perform it. And said, when I finally asked him, well, excited delirium, well, I couldn't call it that today, because it's no longer a thing, and it probably never was. I said, well then, doctor, What killed Alexander Rios? Well, I don't know. I think you use your collective recollection. I believe he threw up both of his hands, literally, on the witness stand when I asked him. Well, I don't know. That is unacceptable. He's the coroner. He signed a pathology report. I don't know, in this day and age. You can't accept that. That's a cop-out. You do know. You do know. You saw a man standing on a guy's back who couldn't breathe and was gassed. Yes, you do know. But you don't want to say because you dug your heels in 4 years ago and called it some debunked science. I don't know from the coroner. I'm guessing he probably swallowed a bag of methamphetamine, I'm guessing. What? Really? And then you got Dr. Burwell sitting there telling you that the guy's as blue as my suit, saying that he can't tell what color Alexander Rios is. As he's laying there blue on the ground with Cooper kneeling on his back staring right at his face. Couldn't even concede that. Wouldn't concede that. And here's something else to consider about Dr. Burwell in his testimony. He claims that he never saw that handheld video. Remember? He said, I didn't see that one, I saw a different one. But Bob Ball, my investigator, took it straight down to the Montgomery coroner's office. Remember him saying that? Well, how is it that Dr. Paul and Dr. Lehman said the only video they ever saw was the handheld video? Think about that. Remember when the autopsy was, ladies and gentlemen, from the evidence? It was Monday morning at 9 a.m. in Dayton, Montgomery County. I don't know if it's Dayton. That's probably a two and a half hour ride. When did he see the video? When did he see the video? You think he went into his office on a Sunday afternoon and reviewed that with Bob Ball, or 5 o'clock in the morning, because Bob Ball made it on time to the autopsy? He was there at 9 a.m. Means he had to leave here sometime before 7 o'clock in the morning. When did Burwell watch the video that he claims he saw a different one? And how did he get it? He never watched the video. He never did. He probably has since. No one thinks this is coming. But he never saw that video. And just like he saw a different video, it's just like Alexander Rios wasn't blue. So let me ask you this, ladies and gentlemen. You got three doctors. You got Dr. Burwell, you got Dr. Lehman, and you got Dr. Mitchell. And you or a loved one is facing an important medical decision, a life or death medical decision. Burwell and Lehman say, don't get the surgery, you're going to be fine. Mitchell tells you, if you really get the surgery, you're probably going to die. Whose advice you take? Who's more credible? Who do you put more stock in? Who do you believe? And who do you trust? Because that's what it is in this case, ladies and gentlemen. They have different opinions. But don't throw up your hands like Mr. Mayor wants you to do, because that's a win for him. Everybody throwing up their hands is not acceptable. We're here to do justice. And remember what I told you in voir dire, that nobody ever said it was going to be easy. Nobody ever said that. In fact, just the opposite. It's going to be hard. Finally, before I play that video for you, these 8 seconds are very important when you see, and I want you to pay attention to this because I don't want to stop it, and I'm not going to play it all the way through, but just to the important part. When Mr. Cooper lifts his foot off the ground and then eventually puts it on Alexander Rios' shoulder and back. I want you to listen carefully, because you're gonna hear the air leave his body with a ghastly grunt. That's him, that's Rios. He goes, you're gonna hear that. And then maybe struggles and maybe has that whistling sound one more time. But he didn't stop.
What's his last name?
Rios.
Rios, I need you to come down so we can. Okay. Alright. Alright. I'm not gonna call anybody unless you come down from down here. Okay, this is the last time I'm gonna ask you. I've asked you for like 5 minutes. I'm not gonna do it anymore. Okay? We're gonna put you in a restraint chair for your safety. Do not listening, be uninvited, causing a risk to harm yourself. We don't have time to continue that all night. Okay? Alright, this is the last time I'm asking you. We're gonna go in, we're gonna go ahead and put you in the chair.
Why don't you just open the door?
Alright, come on down. No. Is that a yes or no? Go ahead and turn around, place your hands behind your back, and cuff up for me. If not, we're gonna come get you. Alright. No? Okay.
I know I said I wasn't gonna stop, but ladies and gentlemen, I'll say this one thing, because I forgot to mention before I played it. When Mr. Mayor says he's being confused and delirious, I'm not supposed to be in here. He's conflating that to mean he's not supposed to be in jail. Another reasonable explanation for that statement is he's not supposed to be in that cell. He's not gonna hurt himself, right? That's what a reasonable explanation for I'm not supposed to be in here. I don't think he's saying I'm not supposed to be in jail as a general proposition. And when he says call the law, obviously there's corrections officers in front of him. He could mean call the court, right? That's the law. So these maybe aren't as confusing as they're made out to be.
Let's go. Go.
Jump to the left-hand corner, please.
Talk to me. Hands behind his back.
Here's your taser. Crazy. Take off. Taser. I'm not even fighting him. Last week I got the glass on. Taser. Ow. All right. Can someone can you explain to me? Because you're a dumbass. Now you're the dumbass. I didn't say you were her.
Fucking took off on himself.
Really?
Yeah, he's like.
Oh!
Give me your hand behind your back.
Oh shit.
Somebody take it.
He's on some type of.
Keep playing.
You need to.
Dear, keep playing.
Rios. Alexander Rios.
Let's go over this one more last night.
Yeah, he thinks he's supposed to be out of here and he didn't get out the wall.
Turn it off. Let go of the cup. I'll fucking. Let go of the cup.
Right up there on the wall.
Pull that thing out.
Get a pair of shackles.
We got another kid. Can you come? Where's the other guy? I got it. Where's that? I don't know. I only have one new guy.
You want a pair of shackles?
So I get inside me.
He's got it. Grab some, oh, he's got it. We got shackles. Alright.
Yeah.
Shackles.
He don't even have any fight in him. Zero fight in him.
Shackle him down there.
Damage is done. Pump. Pump.
Where's the latest? Is that somebody too big? Let's let this foot up there.
Alright.
Somebody else cinch up around his ankles. Do his ankles now, so.
I'm sorry. That's where I'm holding it. I can't allow. I can't. They have not even noticed yet.
Alright, I got the chair so it doesn't lose. Okay. You two ready? Whose turn? Straight up. Get off.
He's turning blue.
Yeah.
Call squad. Master Control, call the squad.
He's limp, he's blue, and he's still here an officer that's angry. Get up! Really? That's the mood in the room. No one's trying to help him. Nobody's trying to help him. And so here's what you know and Mr. Mayor ended on reasonable force, right? And it is an important definition. Use of force shall be limited to the amount of force necessary to control a given situation. In no event may physical force be used as punishment. The kind and degree of force an officer may use in executing his duties, not beyond his duties is limited, and here's the important part, by what a reasonable officer in the same situation would believe is reasonably necessary in the same circumstances. We only had a person like, wait a minute. Lieutenant Odell. We got another officer in the exact same circumstances. What did he tell you? Not only are we taught that you can't stand on somebody's back, you're taught not to do it. We can do it under certain circumstances. No, he didn't say that. They're taught not to do it.
Hold on, is there an objection? Actually did say that. Okay, well, again, this is argument. Ultimately, you will decide what the testimony was. It's your memories that matter. And like I said, none of the attorneys are trying to misquote. It's just during the course of the trial where you have a lot of witnesses testify, it's hard to remember exactly what they said. So that would be the cautionary. You may proceed.
Thank you. He told you they were taught not to do it. Lieutenant Odell, have you ever stood on somebody's back? No. Would you ever stand on somebody's back? No. A reasonable officer in the same exact circumstance. You don't have to compare it. He was in it. He was in it. No, would not do it. Officer Odell, you did not use deadly force in this case, did you? No. Was it necessary in this case? Remember that question? And I think you all do because you remember the long, long silence. And then he didn't answer the question. He didn't answer the question because that's his good friend sitting there. And I get that. I mean, I understand that. But I think you got your answer. I think that was the answer, right? A reasonable officer in the same circumstances. A reasonable 5 officers in the same circumstance. None of them stood on Alexander Rios' back. None of them, except for Mark Cooper. You can talk about body weight and all that other stuff all you want. But none of them stood on and put pressure on Alexander Rios for almost 3 minutes. And yeah, we can talk about the 8 seconds because those were the most important 8 seconds because that's when the most pressure was being applied. We can agree to that. But that doesn't mean that what the force he was using before and after, he stood on his back with both feet, didn't have some effect on allowing Alexander Rios to get oxygen into his body and therefore into his blood and therefore into his brain. This is what we know what killed him. And we know that. I think we can all agree Dr. Burwell's opinion can be disregarded. Heck, he wants you to believe it's a drug overdose. Honest to God. Yeah, maybe it was. Yeah, okay. There's your coroner. Determining cause and manner of death. That's what he said. Nobody else in the world has said that, except that man. The guy who says that Alexander Rios isn't blue. And that he watched some different videos somehow before Bob Ball took it to the Montgomery coroner's office. So then you're left with Dr. Mitchell and Dr. Paul versus Dr. Lehman. And Dr. Lehman doesn't tell you how he died. Dr. Lehman says, no, I don't know. I don't know what killed him. Doctor, you're aware that there's people that disagree with you and could say positional, oh yeah, I'm aware of that. And reasonable people can differ about that. So even he kind of conceded that it could be that. I won't say that. But I guess his professional conclusion is, no, I don't know. I don't know how he died. Well, we do. We do know how he died. And, ladies and gentlemen, Alexander Rios wasn't without his problems in life, right? I mean, we never hid from that. He's in jail. He's in jail lawfully. Not saying that he wasn't. Not saying that he didn't have an addiction problem that so many, unfortunately, so many people suffer from nowadays. I don't know if he ingested methamphetamine that day or when or how or whatever. And I agree with Mr. Mayor on one thing, I wish we knew, but we don't. But again, ladies and gentlemen, even if he did, or maybe even more so, isn't it their job to help him and help people like that? Were they really in danger? Was Alexander Rios armed? Were they afraid? Was he, talk about him not being injured, was outside of Mark Cooper getting accidentally, and that is an accident, accidentally tased. Did you hear any evidence of any of the officers being injured whatsoever with even scrapes or bruises? No, you didn't. Mr. Superhuman Strength that got taken down twice by a single person? You saw that. Where's the superhuman strength there? Excited delirium. This was a guy who was in jail, and if you believe Dr. Mitchell, in crisis. I think I kind of agree with that. In crisis. Standing with 5 officers at the door. 5 officers, right? Reasonable to assume he's been in jail before. He knows what's gonna happen when they open that door. He doesn't want what happened to him down here to happen to him up in his cell. That's why he took off out of that cell. He didn't want to get what he knew was coming, because he knew those officers were not happy with him, and there was 5 of them. And he's one guy naked in some smock. So yeah, he ran. He ran. He doesn't deserve a death penalty for that. Judge, jury, and executioner. That's wrong. That's wrong. They had him under control. He couldn't even find a spot to get in the fray. Couldn't even find it. And so he used his foot. These people in that situation, in those situations, every single person in jail deserves to be protected, ladies and gentlemen. We have to have our jail safe. We have to. And when people die under these circumstances for no reason, then we can't let that go and just say, well, we don't know what happened. We're gonna do an in-depth autopsy, and we're gonna find some cause of death that doesn't exist, and we're gonna dig our heels in, and I'll have the coroner sign off on it, and nobody will be the wiser. No one will ever look at this case again, because as you've heard from the defense for a week and a half, Alex Rios was a drug addict who wasn't worth it.
I'm gonna object. That's the 5th time he said that, and it never once came out of my mouth, and I think that it is bordering on misconduct.
I think that, ladies and gentlemen,
Not directly.
what needs to be argued is what's in evidence, so also the team objection.
Well, he spent a long time telling you about his drug history and his drug past, and how Mr. Mayor talked about his heroin OD in his closing argument.
He 100% did.
So, they've certainly done a good job of assassinating the character of Alex Rios. And that was intentional, clearly.
Again,
But those are the people.
I'm not commenting directly on character assassination, defense motives, specifically.
Again, ladies and gentlemen, the case is decided based on the evidence that is presented in the courtroom from the testimony of witnesses. So whether either side is making arguments, they're allowed to make passionate arguments, but the actual evidence in the case comes from the witness stand. So that's why I've been telling you before, what the attorneys say is not evidence, it's argument. What the actual evidence is what the witness's testimony was. So, you may continue.
Thank you.
Assistant Prosecutor Sullivan.
Ladies and gentlemen, you decide why then, I'll put it this way. You decide why that evidence was put on in front of you by the defense. You decide. You decide why they did that. Felony warrant. Every time they said warrant. Felony warrant. Drug addict, drug overdose. High on methamphetamine. All of that. So what? So what? He was a man, he was a father, he was a son, and he was flawed. But he did not deserve to die in the hands of the Richland County Jail. He just didn't, ladies and gentlemen. And when Mr. Cooper went beyond the reasonableness of force that the corrections officers were allowed to use, that becomes criminal. I don't care what's in their policy. I don't care. That policy does not supersede the Ohio Revised Code. Anybody can put in their policy whatever they want to. Whatever they want to. It doesn't supersede the law. You can read that policy all day long. What if it said, what if they decided to put in the policy that if a inmate acts up, then you can rape him? That doesn't work that way. They don't get to make that policy. They don't get to make the policy of what kind of force beyond the law you're allowed to use. And if they do, then that does not supersede the law. It just doesn't. Nowhere are you going to get an instruction from this court that use of force policy supersedes the Ohio Revised Code. Alexander Rios died because Mark Cooper committed involuntary manslaughter and reckless homicide, both, all three, I should say, all three. He is guilty of all three of those counts, ladies and gentlemen. We ask you find him so.
Thank you, Assistant Prosecutor Salisbury. Now I'm gonna go to the last part of my instructions, ladies and gentlemen. First and foremost, during your deliberations, you may not consider or discuss the subject of punishment. Your duty is confined to the determination of whether the prosecutor has proved or failed to prove Mr. Cooper guilty of the crimes that he's been charged with. In the event you would find him guilty, the duty to determine punishment is placed by law upon me within the narrow limits set for me by the Ohio General Assembly. You must not be influenced by any consideration of sympathy or prejudice. It is your duty to carefully weigh the evidence, decide all disputed questions of fact, to apply these instructions to your finding and render your verdict accordingly. In fulfilling your duty as jurors, your main effort must be to arrive at a just verdict. If, during the course of the trial, I said or did anything that you consider an indication of my view on the facts, I want you to disregard it. Like we said before, jurors, not the judge, decide disputed facts. Consult with one another and deliberate with the view of reaching an agreement if you can do so without disturbing your individual judgment. Each of you must decide this case for yourself, but you should only do that after discussing the case with your fellow jurors. Do not hesitate to change an opinion if you're convinced that it is wrong. However, you should not surrender honest, personal convictions concerning the weight of evidence in order to be congenial or to reach a verdict solely because of the opinion of the other jurors. As you begin your deliberations, you will select a foreperson. So I've been telling you, I don't want you to have an opinion, I don't want you to have an opinion. It's about time for everybody to have an opinion, and the foreperson makes sure everybody has a chance to be heard. So when you're discussing, the foreperson should let everybody in the room offer opinions, make sure everybody has a chance to be heard. However, I don't want you to think that the foreperson's vote is any greater than any of the other jurors. You're all equals, all 12 of you are equals when it comes to voting, and your opinions are equal. Whenever 12 of you agree on your verdicts, you will complete the verdict form, sign them in ink, and summon the bailiff. I will then return to the courtroom where I will read your verdict out loud. So when I come back in, what I'm gonna do is I'm gonna have to say, you'll let us know you've rendered your verdicts, you'll knock on the door, let us know. I'll come back, and I want the foreperson to be holding the verdict forms. When I come back in, I'm gonna say, whoever it is, are you the foreperson or the jury? Yes. Has the jury reached its verdicts? Yes. May I have them? Then I will have the bailiff bring the verdicts to me, and then what I'll do is I'll read it, what your verdicts are out loud in the courtroom. Until your verdict is announced in open court, I don't want you to tell anyone the status of your deliberations or the nature of your verdict. And like I said before, if you're watching videos or something in front of the bailiff, you're not deliberating in front of her. You only deliberate after she leaves, just the 12 people. You're gonna have some control over your own schedule at this point. You may take a break at any time by signaling the bailiff, letting her know you wanna take a break. If you do take a break outside of the courtroom though, you do not resume deliberations till all 12 of you are back in the courtroom. So if you're on a break and there's some people in the restroom and some people in here, the people who are in here are not deliberating until all 12 of you get back in here. You only talk about the case as a body of 12. Typically, and I've told you before repeatedly, there is no right or wrong amount of time and there is no right or wrong answer. Whatever verdicts you come up with, those are the right verdicts. If it takes you an hour, if it takes you 10 minutes, if it takes you a day and a half, whatever it is, it is. But one of the things that I do as a judge is typically, if we haven't heard anything from you around 5 o'clock, we'll knock and see how you're doing. And if you're, say, Judge, we think we can finish up if you give us more time, then I'll let you continue deliberating. I typically don't let juries deliberate past 6 p.m. My concern of that is, and some judges do allow that, I recall a trial where I was involved when I was one of the parties out here, and it was after midnight, and the judge had the jury still deliberating, and that the concern of that is, you need to make the decision on your own. You only do that after talking with each other. But what I don't want is maybe some of the younger jurors to outlast the older ones. I don't want this to be like a marathon session where somebody just says, I'll go along with the rest of you because I'm exhausted and I want to go home and I need to take my medicine or something like that. So I don't let jurors deliberate like that. I would say if you can't come to a verdict, that's fine, we bring you back and have you continue deliberating the next day. If so, we could bring you back tomorrow. I have court, but I could always go downstairs to a hearing room and handle my court down there. But again, whatever amount of time is the right amount of time. There is no set time that says you have to decide it within this period of time. Whatever it takes is whatever it takes. If you have cell phones with you, some judges take away your cell phones. I don't do that, but I make sure you know that you may not answer them and you may not use them during your deliberations. You must conduct your deliberations discussing the case with each other without any outside influences or disturbances. If a problem would come up during your deliberations, what I want you to do is place any request or question in writing, have it signed by the foreperson, signal the bailiff, and give it to the bailiff. If your question can and should be answered, it will be, but please continue your deliberations while you're waiting for the answer. What we're going to do now is we're going to make sure all the exhibits are in order, and if the attorneys say the exhibits are in order, it's time for you to begin deliberating. Well, we can't, oh, she's reminding me, thank you. We have 13 of you still healthy, one of you is an alternate, so I need to figure out who that is. And then I have some instructions for the alternate. Juror number 13, Joshua Hutchinson. Joshua Hutchinson, you are the alternate. Let me say a couple things to you. First of all,
Yeah, they totally doxed that dude. So yeah, now they cut the sound on that real quick. Trying to figure out what's going on here. I guess this is what it is for the moment. Gotta wait it out, see what happens, right? Gotta wait it out, man. Yeah, excuse me, I had to take a break for a quick second and go to the facilities. The facilities. Yeah, yeah. And I apologize about the dog as well, but I really don't, because life doesn't stop no matter what. And that's no disrespect to anybody or anybody's family, but my dog comes in here because she's tired, crazy, whatever. Oh no, man, I'm taking that. I want all that money. My dog is the best. I love her. This is my baby girl. So, kind of apologize to you for the little distraction there, but I really don't, because like I said, life happens no matter what. I mean, anything could happen, right? I'm watching this, you're watching this. God only knows. We're lucky people. We're very lucky people. And I thank you for being here. I really do, from the bottom of my heart. It means a lot. It means a lot.
fine. I'd start with 2 to see if that's enough. And go from there. So we'll let you have your break. We'll make sure the exhibits are in order. When you come back in, return the courtroom over to you to deliberate. Thank you.
So now I guess the deliberations start. I'm thinking, yeah. I know what I'm thinking. Thinking I don't want to watch this soon. That's for sure. I'm sure you're thinking the same. So, what do you think? Guilty, not guilty? Do you believe he was messed up? I do. I do. However, I've already stated how I feel about the rest of it. Shouldn't have went down like that. the prosecutor, he's good. He's the gun. He's a gun. But anyways, no, seriously, in all seriousness, my thoughts and prayers are with the family and the friends of Alexander Rios. And I don't know. I'm going to make a decision here on whether I'm going to stop this one and start another and just let this roll. Uh-oh.
For the bailiff, if she's going to play some videos, we'll wait till she gets back up here.
Well, I can hand that to her.
Oh, that's
for the
perfect.
record.
Sure.
For the record, I started the video at 3:15 and 58 seconds in the AM on the bottom scroll. I stopped.
Little too fake out there, huh? We had hot mics and all. Just leave that up there. See what happens.
Thank you very much for that.
Well, we're gonna stay on the record to make sure the exhibits are in order. So what I wanna do is make sure both sides agree all the exhibits are in order.
C was withdrawn.
C is the duplicate exhibit of the multiplex.
Is there a video still on the phone?
There it is. Yeah.
Yours appear to be here, but good.
That is still in there.
Our 7 are all here.
The prosecution indicates their exhibits are all in order, correct?
Yes, that's correct, Your Honor.
Thank you.
Okay, so what are the times? Which is
That's generally, you want us to leave our cell phones with on or something?
yeah, that would be.
Mm-hmm. Yep. Yes, they did it again. Yes, they did. See what goes on here. Yeah, like I said, I'm not sure what I should do first here. Put that on for a minute. It's been playing low-key in the background. I don't know. Figure it's a good security measure, actually. But anyways, let me figure something out for this here, and I'll be right back. As soon as this pops back on, we'll be back on. The jury is deliberating. Not much to speak on at this point. Yep. I know everybody wants to troll me on out. the stream. This is yeah, it is what it is. Guess we're on verdict watch now. We're waiting to hear what the jury has decided. I don't know why I said that so apprehensively. But anyways, God bless, all the best. It's been 6 hours and 4 minutes. I appreciate you all. Anybody that's sticking in. We are officially on verdict watch. If they come back, I'll come back. If they don't, I'll see you when they come back. Yeah, I don't think we're going to hear nothing tonight. That's, I'm feeling that's pretty much a guarantee. Tomorrow, I'm going to do my best to be here first thing. I'll be monitoring, and I'll try and jump in if I can. Yeah. That's the only way I can put that right now. But we will be live when it goes on. If we, yeah, we'll be here. We'll be live. So please do be as well. I appreciate you all. Take care of yourself. Take care of each other. God bless, all the best. South Philly Hillbilly. Peace. I'm out. Now I'm out. Goodbye.